daily list. Admission matter, my lord.
Yes, I'm posting it, but it will be subject to other business, huh? Because today we have a truncated court time.
Lordship, today I have two things, partner matter, so Lordship may another day.
No, we'll see. This can't be a ground. Parted matter, you may have some.
Even Lordship,
And the DC has
We'll
to-
see, we'll see.
DC is to file a affidavit.
Please ask your junior to pass mask pension. Yes.
May I please, your lordship? Lordship, I beg to mention for listing of a matter in admission column. On last occasion, we were instructed to file an additional affidavit and we have done it. So matter may come up on next Thursday, my lord. Because tomorrow list is already out.
Now, what is the matter?
Matter is regarding service matter, lordship, regarding Dibrugarh Medical College.
Lordship, in this writ petition,
Hmm.
I challenge the resumed extension of the suspension order. Because the suspension, the review of the suspension was not done within the 90 days prescribed under rule, sub-rule 6 and sub-rule 7 of rule 10 of CCA rule
His suspension was under rule 10-1 or 10-2?
10-1.
10-1.
Lordship, if it can be taken up tomorrow, Lordship, SK Mehdi was interested, he is on leave. So I am in the morning and moreover, we have filed an affidavit yesterday only. That may come to the record in item number 13.
30.
Tomorrow, Lordship.
Then we'll take it up on Friday then. What is the urgency?
Friday, Thursday,
Ah.
Lordship, we'll be out of state. That
Oh,
Odisha
somebody-
conference.
Huh?
We'll be
Odisha
going to the
conference.
conference, Lordship.
You will go for conference and we'll deal with your cases. Sorry. We'll see. This is a motion. We'll issue notice. What is the,
Your Lordship,
we can
That
issue
can be
notice
done,
today.
that can be done, Lord.
That's a interim prayer, the subsistence allowance, so only been given 50%. After 3 months, may I pray that it be given till 75%. And the petitioner, he has been confined to the quarters only, he has not been allowed to go on leave. Now, as per FR 55,
You are not paying subsistence allowance.
That has been paid.
only 50%,
And you, according to you, how much you should get?
75%.
Then Why don't you get the instruction on that?
Lordship, Lordship,
We'll have it next week then.
Lordship,
You have your conference in peace. And then let him also remain in peace. Yes,
Lordship.
Mr. D. Bora, learned counsel for the petitioner is present. And in this writ petition, the basic challenge is to the extension of the order of suspension issued by the authorities on 1/11/2022. Full stop. It is also the submission of Mr. Bora that only 50% of the subsistence allowance has been paid to his client till date. And he has also been confined to the official accommodation by restricting his activities, as a result of which the petitioner has suffered serious prejudice. Full stop. Mr. B. Chakravarti, learned CGC, prays for a week's time to seek instruction and appraise this court as to the reason why 75% of the subsistence allowance has not yet been paid to the petitioner as alleged in the petition. Full stop. In view of the above, let this matter be listed again on we'll have to have it on 14th of March. Before that, not possible. Huh? 14th of March for motion along with item 13. If the extra copies of the writ petition be furnished. Let him obtain instruction and 2 extra copies of the writ petition be furnished to the learned CGC. No, suspension we'll see. You will go for Ajay Chaudhary. You will go for which one? The 2003 decision. What is that?
I have to check.
Arvind Kumar or Ravi Kumar something? Rajiv Kumar.
I'll go for Deepak Mali case, Your Lordship.
Huh?
I'll go for Deepak Mali judgment, because Deepak Mali judgment of the.
What is the
Honorable
Deepak Mali shows? What does Deepak Mali say?
Deepak Mali says that the review has to be done specifically mandatorily within 90 days.
Deepak Mali's citation, which year?
It's a 2010 judgment.
Before Ajay Chaudhary.
Yes, yes.
But Ajay Chaudhary deals with Deepak Mali.
No. Ajay Chaudhary deals with suspension, but Deepak Mali specifically deals with this particular issue. That review has to be done within 90 days. After 90 days, the suspension or the extension order becomes, it lapses. And-
Which is the relevant para?
Para 11, Your Lordship.
So review was done after the expiry of
After
90 days.
So my case is basically after 90 days, the extension order doesn't exist.
So you have an extra copy of this? I'm keeping this.
Yes,
here,
yes, yes.
So that
I
I
have
can
extra
come.
copy.
prepared.
2010. 2 SCC.
Check it out,
Okay.
Mr.
Lordship.
Check it out and save some embarrassment.
There's also
You
judgment.
can
from your
yourself withdraw it if you want. Advise your clients.
Lordship.
All right.
There's also judgment which fell from your lordship. It's 2019. 1 GLT 804.
What has been held there?
therein also your lordship held that the review has to be done within the 90 days. After 90 days,
Give the citation,
2019 1 GLT 804,
paragraph.
paragraph number 16.
Anita Basu.
It's
All right.
titled AK Adhyapak, Dr. AK Adhyapak versus State of Assam.
Oblige yellow.
I'll record your presence. Mr. R.K. Talwalkar, Lalit.
5 and 6.
Council is present for respond numbers 5 and 6.
May I please, your lordship. Madam, in this case, respondent have filed an affidavit yesterday, madam. May I pray
I have
for-
filed an affidavit.
2015 matter, you are still filing affidavits.
Lordship, I got the instructions and yesterday I got the affidavit.
We'll have it in January 2024. Why so much of delay?
Lordship, actually, I need to reconstruct the file, your lordship. On the last occasion, I have made a prayer. And my learned friend, he served me a copy with the.
What is the matter about?
With with regard, my lord, the corporate cooperation department has advertised for the post of peon and process server peon, my lord. I applied for the post of peon, but the respondent number 4, who is shown to have cleared the written test from the general category candidate, but he has been appointed in the reserve post, reserve category.
Hmm.
I'm also VC, he is also, he said he has
So
been,
is there any interim order here?
no, my lord.
Then what remains in this case
I am praying for setting aside his appointment.
after 8 years?
Well, I came,
You choose a date of dismissal of the writ petition. We'll dismiss it. You
Well,
just
yes.
get an interim order, that's over. We are not going to disturb someone after 8 years.
no, he has been illegal and my lord, in the affidavit now dealt with that. Why has been general category candidate has been appointed in the OBC category?
Whatever it is, this court is not going to set aside somebody's appointment after 8 years. On those grounds.
And then last occasion, they took time to file affidavit, they have not
Should
filed.
have asked for an interim order.
No, my lord, before I could come, appointment was already, they were already appointed, my lord.
I appear for the appointed candidates.
Huh?
Respond numbers 4, 5, and 6. I appear.
Hmm.
Although they have annexed, they had a corrigendum of the next day, which in fact clarifies that. That was never a part of the record. I entered some days back, and I can just print it on the record. I had it with you.
Right, he is asking for time, so what to do? Mr. S.K. Chakraborty, Learned Counsel for the petitioner, submit a copy of the counter affidavit filed on behalf of the official respondents has been served upon him only yesterday, and therefore 2 weeks' time be granted to seek instruction. Mr. S.K. S. Banik, Learned Counsel is present on
4,
the
5, and 6.
respond numbers 4, 5, and 6. That is the private respondents, full stop. Although this matter pertains to the year 2015 and relates to the validity of appointment given to the private respondents, yet, and therefore calls for expeditious disposal, yet in view of the prayer made by the petitioner's counsel, this court is left with no option but to adjourn the matter. List this case again after 4 weeks.
Item 3 to 7.
Lord, I am appearing in item number 7. The matter relates to, my lord, the age of retirement of Ayurvedic doctors. In fact, this is the issue covered by Supreme Court judgment. My lord, this matter was heard at quite length, my lord. It was reserved and state took time on several occasions. That's why
The
court
order
has
says
released
it's a
it.
parted matter.
So it's released now.
Released from Patan.
Released by whom?
Because state had taken time on
Mr.
several
Justice Surana.
occasions. So court got annoyed and released it.
Mr. Justice Surana,
In
I am
fact, we
appearing,
have argued on at least 3, 4 occasions. My learned senior, myself.
I am appearing in item number
So
3 and 4. নতুন কেউ নেই বলে দিতে।
lordship
Lordship
will
is to
fix
hear
it.
it afresh.
Not that this is very longest matter, it's covered by Supreme Court judgment.
We have submitted.
And all the written arguments of, I think, my learned friend had
But
also.
we,
given-
your lordship will keep it aside, will fresh, file fresh documents, fresh, well, written argument.
I like it, I got to have one.
Actually, anyway, I understand the difficulties. You suggest what do you want?
My lord, lordship will fix a date.
When do you want it?
Not a long either.
9 তারিখ নহয়।
Mr. K. N. Chaudhary, Lawrence Senior Counsel appearing for the writ petitioners. Writ petitioner in item number,
Seven, my lord.
and who is the writ petitioner, other
And
matters?
my
I
lord,
think 3 and 4.
3 and 4.
So, Mr. B.C. Garg and Senior Counsel for the petitioners in item 3 and 4 have submitted in tandem that these writ petitions were heard by another bench at length. But the matters were released from Parker due to the non-cooperation of the state council. Full stop. Today, who is appearing for the state?
Actually, Advocate General appeared in.
Today also,
B. Gogoi and Advocate General.
when these matters were called up, there is no representation on behalf of the state. Be that as it may, since these matters will now require fresh hearing. Hence, on the request
On
of
14th, my lord.
14th, it will come as item 67.
Then 16, my lord.
Huh?
16.
No, 16 my lord.
16th will come as 62.
Or 16.
You have it on 21st.
Okay.
Okay.
Since these matters will have to be now heard afresh. Hence, on the request of learned counsel for the petitioners, let these writ petitions be listed again on 21/3/2022 for admission hearing as fixed matters. Yeah.
Deep.
উপায় নাই রে।
Yes.
Eight lordship, we have filed affidavit in this case, lordship.
No, this was mentioned.
This was mentioned by my senior, sir.
Affidavit is on record.
Affidavit in record, lord. We have filed affidavit, lordship. Affidavit file and reply also filed by the petitioner, lordship.
What is this matter about?
Matter regarding lordship, that caste certificate OBC, Newar community was in the central list or not, lordship.
All right, last item subject to time.
Item 9. Nine lordship, in this case, last occasion when matter was before the honorable court, then honorable court directed us to obtain instruction, lordship, regarding page number 79, lordship. Page 79, there is a letter from the railway authorities, lordship. Then honorable court directed us to obtain instruction whether you have given the names of the retired employee or not, lordship, to the petitioner, lordship.
Yes, yes.
Page 79, lordship, there is a letter from the railway authorities for application of section 12(5) of the Arbitration and Conciliation Act, lordship.
Hmm.
In that respect, honorable court directed us to obtain
What
instruction.
is 12.5 about?
Lordship,
What is 12.5?
12(5) regarding waiver, lordship.
Waiver means, your lordship, after the amendment.
Amendment,
One of you can.
After the amendment, the railway means the organization seeking who can appoint. The employees.
So just a minute, just a minute. You have approached this court seeking appointment of an arbitrator.
Arbitrary.
No arbitrator is named in the agreement. Nobody is named.
no,
No,
lordship.
no.
Now you have served the notice.
We have served the
11:6.
notice and it was the duty as per the amended GCC. They would have furnished us the names of their employees.
Hmm.
Initially, that
So
was.
now
the-
that is over. That period is over.
They did not do so. I have approached this honorable court.
Hmm.
Now, they cannot, even if they issue, means they have
Correct.
forfeited the right to
Forfeited,
seek,
yes.
make an appointment. So
Yes.
we are before this honorable court to make an appointment from the panel of arbitrators. that
Yes,
is-
yes, we do it. What
Lordship,
else?
here, we have written a letter, lordship, in page 79, lordship. The honorable Supreme Court, three judges bench judgment is there, lordship. There we can, railway can appoint the arbitrator from the retired official, lordship. And
No,
against that subsequently,
that part is over because you
Subsequently,
could have done it within the time frame.
lordship, it is within the time, lordship. So lordship may give next week, matter will fix, lordship, I will place it, lordship.
No, 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 no. Don't presume that you will get an adjournment for the
Lordship,
asking.
no, I am not seeking adjournment, lordship, but lordship, the authorities are not able to give the instruction,
Authorities are,
authorities of the railway, lordship. We have seeking the instruction from the railway authority.
that is your internal matter. We can't help it.
No, no.
Law will proceed on its course.
Lordship,
Whether your authorities are
lordship,
vigilant,
Regarding
alive,
weekend-
we can't do anything about it.
we can, lordship, appoint the arbitrator from our retired employee as per honorable Supreme Court full.
Are you agreeable to that?
And subsequently, another judgment is there.
Maybe okay.
Another judgment is there, lordship, that is pending before the larger bench. So lordship may kindly peruse one judgment of our court, lordship. সেইটো দিছে নেকি আপুনি? দিছে। এইটো দিছে নে কোনটো দিছে?
See, Mr. Gogoi, these matters are to be dealt with expeditiously. Only on appointment of
Only
arbitrator.
appointment
if
of
you-
arbitrator, lordship,
Ah,
our ground is that, lordship, we can appoint the arbitrator from the retired employee, lordship.
So let me see whether you have
Lordship,
that right.
that-
now.
that is
If you
what
have it,
decided by
then you
the-
get it. If it is over, then it's over, we'll appoint from the.
This particular judgment deals with the same, between railway and the same parties, your lordship.
Lordship,
Here 30 days
another
period was
judgment
over.
was come before, from the honorable appeals court, lordship. Then, lordship, the matter was, lordship, sent to the larger bench. So it is reflected in that
All
particular
right,
order.
you let him argue.
Lordship,
then-
lordship,
then-
lordship, lordship.
Yes.
Now, your lordship, here.
So where is your notice demanding arbitration?
Your lordship will find
Hmm.
the first, because as per the amended thing, we have to give a final claim. First, final claim is at page 68. Sorry, page 70, annexure E. Thereafter, the notice
1 minute, 1 minute.
under section 11 is page 73, annexure G.
This is your final claim.
Final claim was on page annexure E, page 70. And after, within 180 days thereafter, we have to raise the final notice, and which we did.
Penal con diyor, penal.
Annexure G, your
Mr.
lordship.
Gogoi,
Lordship,
if we accept your argument, then fine. Otherwise, think about the name.
lordship,
If your argument is rejected, I am appointing an arbitrator today itself.
then, lordship, the final statement was on 7/9, lordship, 2017 itself, lordship.
Hmm. So on 21st October 2019,
Yes,
you raised your final bill, final
Yes,
claim.
yes. And 21st October, that was the final claim. Then as per the DCC, we have to raise the within 180, after expiry of 120 days, but before 180 days, the demand for arbitration is to be done, which we did, your lordship will find. Annexure G. Annexure G, page 73, your lordship. And thereafter, the railways, instead of appointing. as per
Acha,
the-
you make your submission, then also place your case. Because if you go on like this, I can't read the notice.
Lordship means, we had made a demand, there was a dispute. We had raised the final claim with regard to some of the claims that was there.
What is the amount you have claimed?
The amount we have given as per the final claim, your lordship will find, is at page 72, is 3,76,56,000. That was the claim, along with various heads we had given, your lordship.
Hmm.
Thereafter, as per the terms of the GCC,
So what happened after this?
thereafter, they did not respond to that.
Hmm.
So we, by our letter dated 17th of January 22, annexure
So
G.
this was 13th of September 2021. Mr. Biswas,
That was the first notice we had given. Thereafter, in annexure I, a second demand we made. By reducing some of the claims in the first demand.
so then the first one goes,
First one goes,
then why are you placing it?
this was the first demand. There were a reduction in some rates.
So Mr. Biswas, the first one goes,
Yes, first one goes.
then why are you placing it?
Then.
How
The,
much time do you want to prepare? You are not prepared to argue this
no,
matter.
no, I'm prepared.
And I am passing the order in 10 minutes. It goes your way or his
No,
way.
no,
You can't get 1 day to argue with these
No, no.
matters. Are you prepared?
yes, yes, fully prepared.
Proceed.
Now,
Where is your notice? We have spent 5 minutes. You have not been able to show the
Yes.
notice.
the notice, the final notice at page I, annexure I, page 15.
Page,
page 77, March 15, 22.
page 77.
Page 77, March 15 letter.
All right.
They received it. And this is acknowledged by them in the next letter, annexure J, page 79. Railway received it on, and they responded to that by their letter dated 17/3/22.
All right. Now, where is the letter demanding appointment of arbitrator?
That was the demand for arbitration. Section, it's annexure I, seeking the section 11 letter, Your Lordship.
No, but where is the request to appoint an arbitrator within?
We submit a fresh claim as per clause 60, clause this is the demand, seeking that this may be within 80 months. We'd like to mention that we, as per the law, this is section 11, they have mentioned, Your Lordship.
Mr. Biswas, you know this notice
I know,
cannot be.
I know, Your
This
Lordship.
is a faulty notice.
They are
You have
seeking
to
a demand
say,
for
where
arbitration.
is your demand? You have to say that we have raised a demand by not responding, you have raised a dispute. We want this to be decided by the arbitration agreement because of clause so and so. So therefore, please please appoint an arbitrator from your part within such and such date, failing which will take recourse to the court of law. There are a number of judgments which says you have to be clear on that. There is not even a whisper of anything of that sort in your notice.
The final letter, it is not
Then
there.
we cannot appoint arbitrator on the basis of this. Sorry.
But they have responded to that, seeking a waiver of the clause.
Where is your notice demanding appointment of arbitrator?
In the second notice, it is not there when we reduced it. The first notice, we had given the demand. Your Lordship.
No, sorry.
In the
We'll write
first
a
notice,
detailed
we-
judgment dismissing it some other day. You rectify it.
Okay.
You know the law. This is a very, very shabby letter written to them. You must be very clear. That
Because in
this
the
is our
second
claim. We raised it on such
They
and such
referred
date.
to the first letter by saying that we are reducing a claim,
No, that is gone.
that
That
they
is
have
gone.
reduced a particular
Yes.
claim and reserving our right to seek amendment.
You want an order on merit on
No,
this? What are you asking for
Just
adjournment?
get further instruction whether
Mr.
subsequent
Biswas,
letters
these
they
are so
have.
elementary. Why don't you advise your clients? So many decisions are there.
But
These are statutory principles which will come into play automatically.
I
You have
know
to be very clear on what you are
that
doing.
is true, but because of
If
the.
there can't be a interpretation for your client in one way and interpretation for
But
them
our
in another.
demand was there, Your Lordship. We reduced our.
Demand was for money. We are
demand
not
was for
deciding your
appointment
demand
of
for money.
arbitrator in the-
Where is the demand?
In the first letter, it was there.
Where is it?
Your Lordship will find annexure. Seventy-three. Annexure G,
73.
page 73. At the last page, page 75. We have stated, we therefore request you to kindly appoint the arbitrators.
But is that letter now valid?
Pardon, Your Lordship.
This letter still holds the field?
We have only reduced a claim, Your Lordship.
That is gone. The claim has changed.
We have reduced, we say that
On the
by
prayer
this
of
claim,
Mr.
we have reduced a
Biswas,
particular
learned counsel for
amount,
the
because
petition.
as per that, it goes to the civil court.
It's over. You first make a demand for appointment of arbitrator
Yes.
and then come to the court.
That
can
is
either withdraw.
75. Your Lordship.
No, then I will have to dictate a judgment. That stance you have changed.
Only we reduce the.
So how
claim.
do you know? That claim they may not have agreed. You have changed your claim.
Yes,
Now they may or may not agree.
they have given the response that you waive the right, we are going to appoint. By their conduct, they have waived their thing.
All right. Mr. Biswas pays for and is granted 4 weeks time to examine the legal issues arising in this case and take remedial measure. Mr. K. Gobal, Standing Counsel, NF Railway, is present on behalf of the respondent. Mr. Biswas, these things have to be crystal clear. Once everything is settled, you can't travel in the haze of this claim, tomorrow that claim, and then say, last time I said appoint an
This was a-
arbitrator.
so I
You
understand, Your
can't do
Lordship.
that.
It was a continuation with the.
It
correspondence.
cannot be. Moment you change your claim, the earlier letter is gone. Insofar as appointment of arbitrator is concerned.
They did not make a specific demand in the second letter.
Huh?
in this only reduced it by referring to the earlier.
Absolutely. If you want the statutory provision to step in, to kick
Yes.
in, you have to follow the mandate of law.
Understand, Your Lord.
Otherwise, they will say that we'll appoint our own railway officer and we'll have to allow it. You can't have it both ways.
That was not the.
You examine it, Mr. Biswas,
Yes,
examine it. And if it is necessary, you take steps.
Yes, sir.
Because if they are smart, then it will be difficult for you.
Yes, sir.
That law will kick in the moment you can show that there was an unequivocal demand for appointment of arbitrator in the context of a dispute which you have raised, which they have repudiated either expressly or impliedly. That relates to another letter which is non-existent. That letter, you have given up your claim, you have changed it. Even if it is a difference of 1 rupee, it is over.
We reduced the claim
Yes,
from that earlier.
Yes. So the new demand, where is the appointment of arbitrator?
That
requirement?
specific line
Then-
is not there.
then next matter, please.
If I pray for adjourning the matter for the time being.
Sorry, no time being today. Either you do it or we adjourn it.
Mrs. RDD is on late lordship.
All right, on the prayer of Mr. Vinder, learned counsel for the respondent, this matter stands adjourned for 2 weeks. Your name, please?
RDD.
Mr. Ardeka is present on behalf of the late petition. Yes, Mr. Gogoi.
My lord, my entire case hinges on particular one point. Whether a diploma holder or B is entitled to the post of member secretary for licensing board of the electric department. There is a moot question. My lord, I am on the verge of retirement. I'm retiring August this year. My lord, I am a diploma holder. I was appointed for this post licensing board in 2021 and some few days for 2022. Now, my lord, the respondent of files, which B, his post has not yet been confirmed. I don't know what method they apply to put him in the licensing. As a matter of fact, diploma holder used to be appointed to the member secretary. There is one Mr. Ajit Gogoi. He was appointed, though he was a diploma holder. Because I was appointed for two terms to the post of member secretary.
Member secretary of?
Yes, the electing licensing board. Electricity licensing board. I'm the member secretary.
Electricity Licensing Board.
Yes, I was there. Even a diploma holder of earlier years also they were appointed. Suddenly they took a title saying that you cannot be the poster. I don't know. This is basic facts. This is law. And basically, well, I am left with only few months to go for it. Yes, let them talk. I will
Yes.
come back.
You are appearing.
I am appearing for the respond numbers 1 to 4. We have filed the affidavit on behalf of both respond number 1 as well as respond number 4. Now, if your lordship permits to the affidavit filed by respond number 4 at paragraph number.
Oh, just a minute, just a minute. The petitioner says he is senior most, due for retirement in August 23. But his case has not been considered for appointment as member secretary of the Electricity Licensing Board,
Yes,
correct? Instead, the private respondent number 5
yes,
has been appointed. So he is challenging the appointment of respondent number 5.
yes.
Now, what is the criteria for appointment as the member secretary of the board?
He or she has to have a Bachelor of Engineering degree. In the petitioner, he has a diploma in engineering degree.
Actually, where is that law?
Page 61, your lordship, of the rate petition. There's an extract.
Hmm.
Rule 4, under the heading Inspector, Chapter 2.
Yes.
No person shall be appointed to be an inspector unless he possesses a degree in electrical engineering or its equivalent from a recognized university or institution. And the petitioner admittedly, he is a diploma in engineering.
So this is what electricity rules.
Yes, Indian electricity rules
And
1950.
when were these rules amended? Rule 4 was amended when?
Amended, it was amended in 1986 as per the footnote.
All right. So has anybody been appointed as member secretary who is having a diploma?
No, she has been appointed, that's one number 5.
No, earlier has anybody been
Not
appointed?
earlier. Earlier, no.
He is saying yes, you are saying no. What is
Lordship, even just please this, there was this one person, Mr.
you are for whom?
I'm for the private.
So according to you, someone was appointed earlier with a diploma.
Yes, but that is as per the rules. If Lordship reads the proviso to the rules,
Hmm.
because, may I read Lordship?
Yes. Mr. Bora, you don't seem to be prepared. Make way for your colleague. then.
Yes, Your Lordship.
If you're not prepared, ask for time. Don't waste the court's time.
Okay, I just
You
received the
can't proceed in this court without knowing your case. That is a complete misadventure. Yes, which proviso?
Lordship, Lordship may take the affidavit,
No,
Please.
first show me the provision of the rule.
proviso, provided that the appropriate government for a period of 7 years commencing on the date of the Indian Electricity Amendment Rules are brought into force, also appoint a person possessing recognized diploma in electrical engineering and having prescribed experience to be an inspector in respect of low and medium voltage installation only. It was in this respect in 1986, one Mr. Ajit Kumar Gogoi was appointed,
So
and it is
that 1 minute, that was for a period of 7 years.
7 years.
7 years from September 1986 will end in 93, September 93.
That's over.
So has anybody been appointed as member secretary?
Thereafter, no.
No, this is for inspector.
This is for inspector. Now the member secretary, the appointment to member secretary is it has a very specific, it has to be appointed only the senior electrical inspector posted in Guwahati will be the member secretary.
Where does it say? Where is the rule?
Lordship may come to page number 32 of the writ petition.
Page number 32.
32.
Yes,
Constitution of the board,
yes,
3. Point number 4.
yes.
The government shall appoint a member secretary to the board from amongst the senior electrical inspector posted at headquarters of the inspectorate. Now, at present, as per my information, there is no one as appointed as senior electrical inspector at Guwahati. The post of senior electrical inspector is manned by the chief electrical inspector. The chief electrical inspector is the chairman, so he cannot be the member secretary. So what has happened is that this board was not being constituted regularly. The respondent number 5, that is my client, who has been appointed, who is a degree holder, she has been appointed. In fact, she had also been given as a in charge of senior electrical inspector of Tezpur just recently. I had given the order on the last occasion. So, Your Honor, that's why she was appointed as member secretary.
So where is the order appointing your client?
She was not appointed as senior electrical inspector of Guwahati, but Tezpur. That had come after the petition, after this was filed, and I have given the order.
So strictly, if you apply these rules, then even she is not qualified.
If you are not right at present, to become a member secretary, one has to be the senior electrical inspector.
Right.
Neither she is a senior electrical inspector, neither he is a electrical. So if the rules are to be applied in the strict sense, both of them are not qualified, but the board has to function. For functioning of the board, the authorities thought that it should be constituted regularly.
And petitioner is senior to your client.
Yes, there is no
How many years?
He's way senior, 17 years, I suppose. He's way senior to me.
I'm 17 years.
Your Honor, there is also one letter of the judicial department, which Your Honor may kindly peruse, which is page. Running page is 86 and it's in my affidavit in opposition. Running page is 86.
Yes, please.
This is a letter from the Joint Secretary to the Government of Assam Power Electrical Department to the petitioner. Subject views of the Judicial Department in connection with your petition dated 1/10/2018 regarding upgradation of educational qualification. With reference to above, I am directed to inform you that your case for promotion to the post of Senior Electrical Inspector via your application dated 1/10/2018, which was also recommended by CEIA via letter dated such and such, could not be considered since the Judicial Department is not agreeable to the records documents submitted on support of your qualification for promotion to the higher post. So he had applied to the Judicial.
But he is posted in Guwahati.
He is posted. Both of them are posted in Guwahati. And since he can never be appointed as a senior electrical inspector because of his qualification, the authorities in their wisdom thought that because my respondent number 5 will be appointed after 5 years. After 5 years, she will be a senior electrical inspector. So the running of the board has to be there. The board was running it was not functioning in a proper way. So that's why she was appointed on it. So that is the.
No, but the question is, if the rules could be tweaked to accommodate your client, why could it not be tweaked to accommodate him?
That is to
Mr.
the,
Bora? Otherwise, we'll allow the writ petition today itself. You could tweak the rule to accommodate respondent number 5, who has long years of service left. But you could not do that for the petitioner who has spent so many years, who is so senior. Of course, if it was a clear-cut case that he is not qualified and she is qualified, the matter would be different. Is it not a discrimination? In any case, you are not going strictly by the rules.
Your Lordship, I am only stressing on the department is stressing on the educational qualification aspect.
No, but even the private respondent does not meet the requirement of rules.
Otherwise, she is educationally qualified.
She is educationally qualified. He meets the posting requirement.
He meets the posting requirement.
Then
The department in the affidavit, they have stated that he is not meeting the educational qualification.
that's all right.
If that is the case, Your Lordship, then I have to seek instruction whether that.
Seek instruction, but tell us that too. Otherwise, we'll set aside this order. Why have you taken to see this man has spent his whole life. He's retiring in August. If you could do so much for the other person, why can't you do this much for him? Of course, we will go by touchstone of Article 14.
Tomorrow, Your Lordship.
Tomorrow. What will happen tomorrow?
Your Lordship, I have to actually.
Have you understood the point?
I understand, Your Lordship.
You are hiding behind the rules,
Yes, sir.
but you are doing it only for him, not for her. Why? What is the big deal?
I understand. I have to just get the.
If you want, we can say that it will not make a precedent. We can clarify that it will not make a precedent. He is going in August. We are already in March.
I understand.
March, April,
I think
May,
there is no
June, July.
financial
August.
benefit attached to this.
Sorry?
There is no financial benefit attached.
No, but he wants financial benefit may not be to his to Mr. Gogoi's client. But the point is, he wants to go out with that satisfaction, having served the
May-
organization.
Respectfully submitting, Your Honor, with all that aspect, now looking at it, this board has been constituted after a long time. If Your Honor decides to intervene, now what will happen? Now he'll be a part of the board for 3 months. 3 months after he becomes a part of, if Your Honor, he becomes a part of the board, then July he retires. Thereafter again, she will come back. Now for this 3 months, he will come, this board has been constituted for various purposes. She's been working for the last 2 years. Now the point is whether this, as per my understanding.
See,
Yes,
Mr.
yes, Your Honor, I
Das,
understand.
the petitioner is feeling humiliated. He is feeling neglected in the organization which he has served for so many years. Heavens will not fall if
But Your Honor, he has been also a part of, he had been appointed member secretary earlier for, as a stopgap member. It is not that he has never been a member secretary. When the board, when it had to run as a stopgap arrangement, 1 year, 2 years, he had
So
got.
was there any problem when he was the
No,
member?
I'm not on that, Your Honor. I'm
No.
just on the point that since it has to be a, it's not that he has never tasted that post. He has tasted that post. He had been given this thing. Now the
Is there
government,
something attractive about that post?
I don't know, Your Honor.
You
That's
give
what, that's what I
You
don't
give up.
know.
You give up then.
I have no issue, Your Honor. I'm just saying on the point of view that I have no problem. If Your Honor says that, I'm just,
Mr. Bora, we can give you a little longer time. What happens is, as judges, we cannot be completely oblivious that persons serving in department, they have certain aspirations which are not measurable in terms of money.
that is.
So if he was earlier appointed as member secretary, if the rules could be tweaked this way, that way, why don't you grant his wishes before he retires? Tell your persons to be a little gracious. We'll have it on next. We'll have it after Holi. We'll have it after. Holi.
Only, well, it will be long period.
Sorry?
Let them get their instructions, my lord. Let them get instructions, sir.
Yes, yes.
Sometime.
Huh?
No,
1 week at least.
No, my
At least
lord,
1 week.
this case will never develop. They have been taking adjournment. They know. They are not.
They have been taking adjournment in
Lost,
this,
well, lordship, we will see the order 6.
before this court.
My lord, in the high court, I don't know in whose court it was. But then they have been taking. They have been taking times.
No.
I filed it, my lord, a long time. Well, you see the
So-
date of filing.
So, Mr. Gogoi, we are trying to find a way out.
My lord.
You have to have a little patience.
My lord,
Yeah.
I made little note, my lord. Your lordship will keep it in the account. Okay. Bro. Bro, okay. Bro. Good, good. Sound good, sound.
See, Mr. Bora, writing out a big judgment is not a problem. We can write it out. Take down, heard Mr. D.R. Gogoi, learned counsel appearing for the writ petitioner. I've also heard Mr. D. Bora, learned government advocate Assam, appearing for the respond numbers 1 to 4. 1 to 4, and Mr. R.J. Das, learned counsel for respond number 5. Stop. The controversy involved in this writ petition centers around the appointment of the respond number 5 as the member secretary of the Electrical Licensing Board. First up, it is the undisputed position of fact that the writ petitioner is about 17 years senior in service as compared to the respond number 5. And he was earlier appointed as member secretary of the Electrical Licensing Board on as many as 2 occasions. First up. However, this time the petitioner has been ignored merely on the ground that he did not possess a BE degree as per the requirement of the rules, as per the requirement of Rule 4 of the Indian Electricity Rules, 1956. First up. According to Mr. Gogoi, the respondents have earlier made a departure from such policy, and considering the long years of service rendered by the petitioner, and in view of the fact that he is due for retirement with effect in the month of August 2023, first of all, the petitioner deserves such consideration for the authorities, so as to enable him to retire from service with a sense of honor and fulfillment. Full stop. Mr. Bora, learned Government Advocate Assam submits that the reason why the petitioner was ignored is only on account of the fact that he is a diploma holder. Full stop. Similar as the stand of Mr. R.J. Das, learned counsel for the respond number 5. Full stop. Be that as it may. No, be the it is no doubt correct that as per the rules, the person to be appointed as the member secretary, persons to be appointed as a inspector must possess a degree in electronic engineering or its equivalent from a recognized university. Full stop. A member secretary of the board can only be appointed from amongst the senior electrical inspectors posted at the headquarters of the inspectorate. First of all, the fact remains that even the respond number 5 does not meet the requirement of the rules for the simple reason that she is not posted headquarters, nor is she holding the post of senior electrical inspector. Full stop. A question therefore would naturally arise as to the reason why the rules could be tweaked to accommodate the respond number 5 and not the petitioner herein, who undoubtedly has a longer experience behind him. Full stop. Full stop. It is in the context of the aforesaid factual backdrop that this court would have to consider whether it is a case of discriminatory treatment meted out by the authorities to the writ petitioner. Full stop. The writ petitioner by applying the rules differentially in case of both the contesting candidates. Full stop. The matter can be resolved by issuing a writ of mandamus. However, since Mr. Bora has prayed for time till 16th of March 2023 to seek instruction and appraise this court as to whether the grievance of the petitioner can be redressed even at this stage, I am inclined to grant some time to the learned Government Advocate Assam. Let this matter be listed as a fixed item on 16th of March 2023. A copy of this order be furnished to Mr. Bora during the course of the day.
Your Lordship, there is one more issue. There is another case pending, WPC 769/2023, Kajal Kumar Sinha, regarding the same issue. Because in that case also, he was appointed as he was seeking appointment as member secretary because he doesn't possess that engineering degree. He was also diploma.
Who is senior to them?
No, you know what had happened, Mr. Kajal Kumar Sinha and the respondent number 5 are similarly situated. So Kajal Kumar Sinha filed a petition when he was appointed as member secretary. For the time he filed a writ petition. In that writ petition, Your Honor, Your Lordship was pleased to pass an order saying that an interim order saying that if any extension is extension is given, that extension will be subject to the course. It's in the writ petition as well. Page number 30. Page 30. So both may be tagged up.
On the request of learned counsel for the respondents, this matter be listed along with WPC number
Publication number 769 of 2020.
769 of 2022.
Deeply obliged.
Obliged.
Item 12.
Lordship, relates to a departmental proceeding and the penalty of censure was imposed upon me.
Penalty of?
Censure, Lordship. I have put it to challenge in this writ petition, Lordship. Lordship, the petition is otherwise eligible for consideration of this promotion, Lordship. And due to this departmental proceeding, Lordship.
Censure is a minor punishment.
Mine.
Then
Then Lordship, he's already been promoted DCF, Lordship.
He has been promoted.
He's been promoted DCF, now he's seeking consequential benefits, your lordship.
That will not decide in admission.
The lordship,
These
let the
matters-
secretary take the call, lord, since he has already made a representation and he's saying that that has not taken call off. So at 121, your lordship.
Appeal is up.
121.
Yes, your lordship, and 24.
Lordship, only the charge at, charge number 2 was proved against him, and against that the penalty.
That's right, you have been promoted already.
Yes, your lordship.
Lordship, but then the further promotion, Lordship, that's being stalled probably because of this appeal, Lordship.
Further promotion has been stalled.
Yes, Lordship.
When was it? When was the DPC held?
Because, Lordship, the juniors, his juniors, Lordship, were being considered, Lordship,
When?
in Lordship, it's on 16th of February 2023, Lordship. An order came to be passed, Lordship.
16th of February 2023.
Yes, Lord.
And you filed this writ petition on India
Earlier.
2000. So that part you want to take care in this writ petition.
Lordship.
So there is no prayer for that, your lord.
It's not there, Lordship, but
So I'll dismiss it then. You should have said that in the beginning. You know what is the law. Taking a chance.
no, Lordship.
Chances
I
don't
have
work
a
out.
prayer, Lordship, to consider my promotion, earlier promotion from the date my juniors were promoted.
How can it be done?
Lordship.
Have you made a prayer?
The earlier
On the prayer of
promotion,
Mr. MP Sharma, learned counsel for the petitioner, this matter stands adjourned for 6 months. Mr. R. Gogoi, learned standing
Lordship,
counsel.
dispose it kindly, Lordship.
No, but I offered it first, then why did you go into 2023 promotion? Why did you want to seek relief for 2023 promotion in a writ petition filed in 2022?
Lordship.
Was it fair on your part to make that submission before the court?
No, Lordship.
Then you have to wait for six weeks. I'm so
I'm
sorry.
sorry,
Call the
Lordship.
next matter, yes.
I just prayed that.
Be
Lordship,
very careful when you open up your mouth before the court.
Your lordship.
Lordship will not proceed after 6 weeks, Lordship. Kindly,
No.
before that,
Mhm.
Lordship.
Why did you make that misleading submission? First explain
I
that.
just wanted to convey that.
No, why?
Lordship.
How is it relevant?
I'm sorry, Lordship.
2023, some DPC has been held. How is it relevant to give relief in a case which was filed in 2022? When I said I am disposing of directing the authorities to consider, you responded by referring to the 2023 promotion. How is it relevant? How is it relevant? You tell me that.
Select
Huh?
list of 17, 18 and 19 were being considered in that exercise. Lordship.
Correct, but the exercise which happened in February this month, can this be interfered with in a writ
No,
petition?
Lordship,
Then
I'm
why
not-
did you make that submission? That's what I'm asking
sorry,
you.
Lordship, for that. I don't know.
Then if you're sorry, then you wait 4 weeks. Yes.
Your lordship.
May please the lordship.
Hmm.
My lord, in this case, your lordship please to see the order dated 16th of February. It is a transfer matter, my lord. At one stage, the honorable court directed us to file an additional affidavit. At the same time, the government was asked to file an affidavit. We are so far as we concerned, we have filed our additional affidavit, but the government has yet to file their affidavit.
If I may, Lordship, may I submit? Lordship.
No, why don't you let him finish? I'm here.
Lordship,
But the government is yet to file their affidavit. That is made clear, my lord, by the order dated 16th of instant. 16th of February 2023.
He wants to say something.
Lordship, the additional affidavit was filed yesterday, my lords. This is a transfer matter, my lords. There is an interim which the petitioner is enjoying. My lords, certain facts have been brought in the additional affidavit, which we received yesterday itself. Lordship, in order to clarify those facts, Lordship, I am just seeking 1 week's time. There's already an interim, my lords. So if my learned
We'll
senior
grant him.
will allow, because
But they are, he was.
No, what do you want? Disposal today?
No.
Then,
They were also directed to file their affidavit.
so they'll now file it. You have
but
filed
there was
it.
an additional affidavit filed
Yes,
yesterday,
yes.
Lordship, because that has brought some new facts, my lords.
Yes, yes,
And those facts are slightly different from the instruction which we have received from the department. Lordship.
yes.
So, Lordship,
You
1 week,
want 1 week or 2 week?
Lordship, after the holy break, my lord.
After the holy
It's a
break.
small issue, my lordship, we can, that can be.
After the holy break.
All right, I heard Mr. B.C. Das, Senior Counsel, assisted by
S.H. Rahman.
S.H. Rahman.
S.H. Rahman, and Counsel for the petitioner.
It-
I also heard Mr. H. Sullivan, learned
Standing
Standing
Council.
Council Health Department Assam, appearing for the respondents who submits that a copy of the additional affidavit filed on behalf of the read petitioner was served upon him only yesterday,
Yes, Lordship.
and therefore 2 weeks' time be granted to obtain instruction and file a consolidated affidavit on behalf of the department covering the allegations made in the read petitions as well as read petition as well as the counter affidavit.
Additional affidavit.
Additional.
Additional.
Sorry, additional affidavit. On the request of the learned departmental council, this matter is directed to be listed again on 17th of March, 2023. In the meantime, the respondents to file their affidavit by
17th of
serving
March.
advance copy upon the petitioner's council. Interim order passed earlier to continue. till then. Yes, till
But
then.
it can be on the next Tuesday, 21, because I have another case before the Lord.
No, but then 21 is not a motion day.
Oh, yes.
Hmm.
Let it be on 17th.
Let it be on 17th. We'll see. Yes. You have any personal difficulty?
No. I have to come.
Your coming here makes us feel good also. You can't deprive us of that.
But I want to complete my 50 years of practice.
Oh, 50 years.
Then this year, why not, if I can complete this year, it will be completed.
Oh, you certainly will.
Hope so.
No, Mr. Das, if you have any difficulty, then tell us.
No. I have to.
Supplemental is for admission item 23.
Admission by success.
Yeah, Pritesh. And this is a small issue. If you lordship kindly peruse the first order of this honorable.
UK না আছে এটাকে বলো মাতিব আৰু এই যে ম্যাটাৰটো আছিল এমপি শৰ্মা হা এটা কোন আছিল এইটো নহয় ফৰেষ্টৰ ইয়াৰ আৰ গৈ আৰ দুজনক মাতি দিব
If you lordship kindly peruse the first order, that is 2/9/2022 lordship.
What is this matter about?
This matter is relating to engagement of assistant branch post constellation. Assistant branch post constellation. But my candidate sir, lordship, after shortlisting the inputting the name of the petitioner lordship. Now, my lord, kindly peruse the order input, that is page 55. Page 55.
You are appearing for the respondent, Mr. Dev Chaudhary.
Yes, lordship, in fact, lordship, the directed me to file the affidavit. My affidavit has come, but I had to send it back, lordship. There were some mistakes there.
Some,
Mistakes in my affidavit, lordship. I had to send it back.
no, but what is the issue is local
lord,
language. What is the local language? Which
My
case is
lord,
this?
my lord, page 55, local language, that is your lordship.
Kachar, what is local language?
My
Bengali.
lord, Bengali.
And what is this gentleman? Is-
My lord, he is Bengali medium. The problem that is your lordship will kindly come page 15.
Hmm.
Page 15. Serial number 2. MIL. Here lordship two options is given, Assamese and Bengali, but there is no tick marks. Now
Actually, what was this?
there should be tick mark in Bengali, that is not given.
Hmm.
My lord, now the school headmaster of the school lordship will have made a party where I studied lordship. He also lordship filed an affidavit saying that my school is Bengali medium and petitioner has
Where is the affidavit?
lordship. Paragraph 4 lordship.
Hmm.
My lord, the condition that is incorporated in the
And
advertisement.
where is the imprint order?
Lordship, page 55.
Hmm.
My lord, the requirement, that is the local language, that is your lordship will find page 20. Start from page 18. This is the notification for engagement.
Page 20.
Page 20, serial number 6, lordship. That was the requirement.
Hmm. So, forget the affidavit. What is the issue here?
Here, lordship, what has happened is, if at all my learned friend's submission is correct, the documents were verified on 8/8/22. On 8/8/22, he did not have any certificate that it was a Bengali medium school. It was both Assamese and that certificate. He got it later on 12/8. By the time the verification was over. And since it is an online verification,
Hmm.
so his candidature was closed on 8/8 itself.
Hmm.
That is the issue, lordship.
The certificate is relied upon was,
He brought it later. On 12/8. Yes.
That page, lordship, I have.
Lordship will see.
then we'll need an affidavit.
My lord,
Lordship will see
55.
page 57 of the petition, lordship. Lordship will see
Mr.
page.
Khan, the date on which candidates are called,
Lordship.
that day they will have to go with the certificates.
My lord, page
If
15.
they have it in home, that is not going to
On
work.
the page 15, that certificate was produced on that very day.
Page 57, then why he has enclosed this?
Yes. Why I have stated in paragraph, lordship 10.
He produced it on 12th, lordship. That is our case.
All right, how much time you need to file the
Lordship,
affidavit?
let it be immediately on this reopening, lordship.
Let him file the affidavit.
And not really-
Because one post is kept vacant.
Already.
Huh?
Yes, lordship.
Yes. Heard Mr. M. Khan, learned counsel for the petitioner, also heard Mr. R.K. Chaudhary, learned DSJ, appearing for the respond numbers.
So respondents, lordship, 1 to
Except
1 to 5, lordship.
1 to 5 and Mr. K.R. Pathiri,
Number 6, my lord.
learned counsel for the respond number 6. Mr. Dev Chaudhary submits that within 10 days from today, the affidavit on behalf of the official respondents will be brought on record and therefore the matter will be adjourned for 2 weeks. Full stop. Considering the nature of controversy involved in this case, this court is of the opinion that affidavit on behalf of the respond numbers 1 to 5 would be necessary in this case. As such, register to list this matter again on 17/3/2023. Affidavit on behalf of the official respondents be positively filed on or before 15th of March 2023 by serving advance copy upon the petitioner's counsel.
Master.
For hearing item 16,
This is the matter where the driver of the CISF was compulsory retired on the grounds of intoxication and
Yes.
the respondent was required to take some instruction on the.
My lord, last occasion, honorable was directed to take instruction regarding the whatever you will get in compulsory retirement, my lord. Just the. come with
Yes.
some there.
He's from the department.
Yes, sir.
Yes, please come. What is your name?
My lord, I'm Dineshwar Tongbram, Commandant, CISF, working in Group Headquarters, Guwahati.
Okay,
I'm working as the LO for the court also for all CISF units in Guwahati.
all right. Have you understood what is the query of the court?
Yes, sir.
See, the courts are always conscious that you are entitled to maintain discipline in your
My lord,
organization. We have nothing to say on that.
my lord.
But we will also go by how the process has been conducted. Now, the only question we are asking is, we find that there are some defects in the proceeding. Right? For example, your inquiry officer is cross-examined. This is not permissible under the law. And there are other aspects. But it has been more than 10 years since he is out.
My lord.
So we also do not want him to be directed to be taken back. If we interfere with the order of penalty and the inquiry, then the natural order is to reinstate him. We don't want to issue that order. Therefore, what we wanted to know from you is that we are proposing to pass an order interfering to the extent required under the law, but no order of reinstatement,
My lord.
provided if he can be given an order of compulsory retirement. Whatever amount is due for the quarter he is occupying, that you deduct. You deduct from his dues
My lord.
and pay him the balance as compulsory retirement. What is your, we don't want your consent for that. We want to know,
Sir,
what is the difficulty it will be arising?
Your Honor,
That's all. We can always pass the order, but we want to hear you. That's
in
why.
this regard, I want to say that at first, the said petitioner was given removal from service. But later on, in his appeal to the IG, who is the reviewing of authority, IG has taken a considerable lenient view, and he has been given compulsory retirement with full pension benefits.
Oh, he has been given compulsory.
Yes,
retirement.
sir. He was, but the petitioner refused to take that one, and still today he has not applied for these pension benefits. जो paper signed करना था अभी तक नहीं किया है. But he is given full pension benefit, even though he is not entitled for benefit because he has not served 20 years of service, which is minimum requirement for a government
Oh,
service.
then what is it? That is all we wanted to know.
That is what I was.
But on the other date, neither, but you also didn't point out that.
That was placed, my lord. That is there in the appellate, the review order, the revisional order states that I had placed it, my lord, he would be entitled to a pension of 2,700 something that was entitled to. My lord, when we challenge the entire disciplinary proceeding, which has led to the revisional order, the revisional order does not say that the inquiry proceeding was wrong. Revisional order accepts everything in the inquiry and then says that from today he goes on a compulsory retirement. Now, if the inquiry proceedings were wrong, my submission was if the inquiry proceedings were wrong, then the entire disciplinary authority order has to go, along with it, the revisional order has to go. My submission was that if he is allowed to be compulsorily retirement or voluntarily retired from the day he completes 20 years of service, since he has completed that by now.
Achha,
What will
voluntary.
remain is, he is out of service even today. He will remain out of service. All that happens is it is not a compulsory retirement as a punishment. He goes for a voluntary retirement of service. From service, he will not enter service. And for this period that he remained out, as is given in Deepa Survase, he will be entitled to the benefits of the back wages, which they will adjust and give me the pension as I would be entitled as on 2023. That now brings my pension up to a level of somewhere near, I do not, somewhere near 20-25,000, with which he can run the family. Whatever pensionary benefits, the DCRG that would have been entitled as of today can be adjusted, whatever is done with that. So I am not against the compulsory retirement that was imposed by the revisional authority. Had it been done by setting aside the inquiry proceedings, no.
All right, I got it. You see, the issue is slightly different. We do not want him to be reinstated in service. Let's be very clear. We are not giving him a clean sheet. but there are many loopholes in the inquiry proceeding, which the High Court cannot ignore. So to find out a via media, yes, it slipped out of my mind. We thought that we will convert the penalty in such a manner that he be allowed to go on voluntary retirement,
Yes,
which will commence from the date of this order,
yes.
but no back wages. No back wages.
Because if the back wages are not given,
Hmm.
even if it is given notionally, if I'm got DCRG, if the back wages are not given, they are adjusting that money
Hmm.
that I'm supposed to pay as the penalty rent.
Hmm.
That never comes to me. Deepa Kundu Survase, my lord, says that when this type of a disciplinary proceeding is set aside, I will be entitled to all the back wages. My proposition was those back wages, they don't pay me. They adjust whatever they have to adjust against the money that I owe them for the penal rent. Whatever remains is what I get. The government doesn't suffer a
No,
financial
but you will
loss.
get full pension.
Yes, from today I will get full
You will
pension.
get full pension from today.
So now, Malak, if from the full pension they start deducting that money,
Hmm.
I will have nothing left at hand. Because that amount, the penalty rent is not 15. If we say that a government quarter, they cut the rent.
What is the amount for government quarter?
Even if it is 500, because
Sir, in the government, as per the government rule, if somebody is occupying this one, the penalty, it's going to exaggerate after some period.
it goes up.
It's up to some 200 times also, percent also, but the quarter given to him, which he's been occupying till today unauthorizedly, is with the management, this IOCL. तो उसमें तो वो गवर्नमेंट का रूल नहीं फॉलो नहीं करते. It's only penal interest, sorry, penal rent of only 6,000 or 5,000 like that only per month after unauthorized occupation. Till then, government rate is much higher, but this 5,000 or 6,000 at present, it's
So that
quite minimal.
rent for the quarter will be deducted by whom?
What they
By
have done is-
ourselves only, and it will be paid to the management
Hmm.
where we are, CISF is being deployed.
So can you not do it without the penal rent? The normal rent, can you do it? Can you do it? We are asking you to be
This
a
one,
little.
we have to request to the management IOCL, and most of the time they give in the favor of.
So what is the non-pen? I'll hear you, Mr. Manu. What is the non-penal rent for the quarter, non-penal?
If somebody is working, they have to pay only the electricity and water charges only.
Hmm.
Otherwise, there is no rent for the lower officers up to.
So very well, now the order of the court, you see, we have to balance every side.
Sir,
And as I said in the beginning, the courts are fully conscious of the fact that you need to maintain discipline in
Sir.
your organization. Everything always is not as per the text of law, but a law court will have to go by the text of law also. So
Yes, sir.
since we have found there are some loopholes, therefore the inquiry cannot be sustained, but we can mold a relief. You treat it as voluntary retirement with effect from 20th year, completion of 20th year, and taking the notional.
full benefit was given at the time also with pension only.
And
Sir.
for the quarter, don't deduct by penal rent. That's all we'll provide.
We will be our department will be ready to give him the compulsory retirement from that day, and this penal rent, we can ask the management to excuse of all the penal rents. We can do that.
If my lord, if I'm given.
Back
the-
wages, our department, I think, with back wages.
The back wages, they are not.
They will not,
my lord,
it is always
my
challenged in
salary-
the law, higher court also.
That's correct.
And-
No back wages.
May I
No
just-
back wages.
my lord, may I just put it this way?
Let's be very clear.
My lord, Let me put it this way, my lord.
Yes.
The day he was released from service,
Hmm.
he had some salary of around 6,000.
Hmm.
His salary was at that point of time for the pay scale was around 6,000, if I'm not wrong. Therefore, he gets a pension of around 3,000
No,
on the day that he
but-
was retiring. 29,000.
No, the calculation is like this. I got the calculation at that time also. At the time he was given compulsory retirement,
Hmm.
his pension was calculated at around 5,325 rupees plus DA. And after some time, due to the pay commissions, we have to make more, the fixation has to be done time to time. And it will be around 13,550 plus DA.
But if they give me the notional benefit, they waive off the penal rent. What I would have got today on my voluntary retirement, if On that basis, it is calculated and given to me, including my DCRG and my continued pension. The petitioner would be. Lordship may record that I have proposed a voluntary retirement
All right.
and I am agreeing to it.
All right.
on those
All right,
terms.
what we'll do is, I'm requesting both sides.
My lord.
If you can just sit down and write it in a piece of paper,
My lord, yes,
type
yes, yes,
what both of you agree.
my lord, yes,
And I'll post it day after tomorrow. I'll pass the judgment I'll pass.
my lord.
I'm convinced that your inquiry proceeding was not correct. You could not prove that he might have been drunk, but you could not prove it. But that's all right. There will be, please understand this very clearly. Setting aside with the inquiry and penalty order is one thing, but this court is not directing reinstatement of the petitioner in service,
Yes, my lord.
not directing.
My lord, yes.
Ordinarily, once a disciplinary inquiry is found to be vitiated, the order of penalty automatically goes. So here also order of penalty will go. But considering the facts and circumstances, we are not directing that he should be taken back, nor are we directing that he should be paid back wages. Correct?
My lord.
So after eliciting a response from both sides, the order I am proposing to pass is this. Number one, that he will be paid the amount payable. If already paid, it will be adjusted. The amount payable as compulsory retirement pension
My lord.
from the date of the order of the penalty till say date of the order of the court. Correct. And from that day, it will be voluntary retirement. And his pension, etc., will be refixed by notionally giving him the benefit, not actual pecuniary benefit, but notional benefit. Since he is in occupation of the quarter,
My lord.
there the rents recoverable may be recovered, but not at penal rate, for which the respondents may take up the matter with the IUCL authorities. That is the order I am proposing to pass. Do you have anything to say, Mr. Commandant?
सर इसमें big ways तो आपके डिसीजन में नहीं आ रहा है, but we have to pay the we have already given him compulsory retirement from 2012 and still today he is not claiming that benefit. That's
That
another
they give
thing.
me, I will.
That we were as per your instructions, Your Honor, we have to get that and again refix in voluntary retirement. That is not possible. Once a person is given compulsory retirement, pay fixation will always do as per time. And calculating again on the basis of ordering in voluntary retirement is not required. Since he has been already in compulsory retirement, the full pension benefit and whatever DCGRS and all, everything is entitled. He will be given.
But what happens for this period?
All those period will be given.
Will be given.
Yes, sir. But since the date of his removal, compulsory retirement in 2012, from that onwards, all areas will be given.
What he is proposing is that I will be treated to be retired from 2012 and with areas now.
With areas, everything will be paid.
I
as
remain to be
whatever
compulsory.
entitled.
That matter does not solve my problem because I remain compulsory retired on that day. My proposal was that I'll be retiring from today. That is when my pension increases for me to support my family and I do not have to fight to get back a job. So my lord, therefore, if they treat me to be compulsory retired from today, for the last the intervening period, they pay me what they had proposed as pension, and from today, what have fallen from lordship. From today, I get the pension as it will be applicable.
All right,
from today.
what I'll say is,
I'll make out.
why don't you both
I'll do
meet
that, I'll do that.
outside
I'll just.
and see, he also has a point.
Yes.
Yeah,
If I'm
because
retired, then I cannot be
the
retired.
accounts part has to be, they are not in charge of that. The CAG, the AG, they will have to approve.
So instead of back wages, that will be the, if we calculate that lump sum around the period for the 2 years.
We'll take
lump
it up
sum
again
taken.
at 2. In the meantime, if you could agree, just
I'll do that, right.
if you can
I'll
give
do
a
that.
paragraph
I'll
on what exactly is agreeable.
do that.
Otherwise, we'll hear both sides and reserve the judgment.
I'll try to.
At 2, yes,
Sort it out.
at 2. Matidog at 2. Dudavasan Matidog. Acha, Mr. Nair, it seems that you are in this case?
I'm in the case.
Your client has already been promoted.
Subsequently, he was promoted to the rank of DCF. The problem now here is because of the censure, his promotion to IFS for 2017, 18, 19 batches have been denied, my lord.
That happened when?
That happened, the meeting was sometime, my lord, towards the end of last year. The orders have just come out. my lord.
But that is not on the challenge.
No, but this order goes, then, my lord, I'll have to file a review of those promotions, my lord. That will be before this central
So
administrative.
it will be a contested matter.
It will be a contestation.
No, but your junior was projecting the matter in a different manner.
My lord, what had happened here was, there were two charges against me.
Hmm.
First charge, not proved. I'm not going into that. Second charge, they say proved. What happened? There was an information on 10th that there one rhino has been killed. But this, in spite of best efforts, this rhino's carcass could not be found. It was found on 14th. This was held against me. That why 4 days you took time to find out that carcass. Now that body was taken for medical examination. Postmortem says that the total body is totally decomposed. Male or female cannot be dismembered. It had occasion around 15 to 20 days back. So this was not the rhino which was purportedly killed on 10th, my lord. So if that be so, the charge does not sustain, my lord. And the charge has to go.
No,
And the
but
order,
you don't have a prayer for review DPC.
where, my lord?
In
No,
the-
here, my lord, I can't make that prayer because that jurisdiction will be before, IFS jurisdiction will be before Central Administrative Tribunal.
Oh, that's why he said that he is pressing that relief here.
No, my lord, maybe he was wrong, but I pray for apology for that. My prayer relief for IFS will be before the Central Administrative Tribunal.
Hmm.
But this order of censure,
Hmm.
my lord, in IFS promotions, if the order but otherwise censure is nothing. Normally in the state
So
government.
why
it's
can't you challenge the order of censure in the central
It will
administration?
not be because this is an order as an ACF officer, I have got it. So this has to be before your lordship only.
Is there urgency in the matter?
Malad can have it because now that promotions have been given, nothing more like that. Malad can have it after a few days. I'll argue.
Then the earlier order remains. But he did not present. in the
I'm
case-
sorry, Malad. I'm sorry, Malad. He might have confused
Has
it.
created,
I'm really sorry, Malad, for that.
all right, all right.
Much of it. Malad, in the meantime, if they desire, because instructions they said they have received,
Yes.
but no affidavit has come out.
So
They
we'll
want-
find lordship.
You file your
Yes,
affidavit.
sir, I will.
Much.
Lordship, in this matter, Lordship, by passing the last order, your Lordship directed me to obtain instruction as regard the nature of regularization of respondent number 6.
Hmm.
In case of other respondents, Lordship, he has already decided not to pay. But that instruction is awaited, Lordship. What they have informed me, Lordship, he is still continuing as a Sokidar, Lordship. But under what, whether his regularization was done with the approval of the authority, not, that document, their Lordship searching for, Lordship.
No, but if the order of regularization is not in accordance with law, then you have to either take action against the person who has issued the order, or we will not, we'll have to ignore that aspect.
Probably, Lordship, they will ignore, Lordship, but only document I am searching for, Lordship. What is the nature of that regularization, Lordship? How it was done, Lordship?
Yeah,
That was
you see, Mr. Nayak, the reason why this order was passed,
Lordship.
we appreciate that many things are happening in the government and everything may not be spick and span. Sometimes the authorities don't realize the legal implications. Sometimes things happen due to a little less vigil. You are running a big machinery, it can happen. But the problem is if somebody comes to the court by raising an issue, we have to answer the question in accordance with law.
Lordship.
We have no option. We have to do it. Even though we may have in the back of our mind the conditions under which your departmental authorities may have to function. Yet we can't decline relief on those grounds. So if you find that somebody has done something which is not purely in accordance with law, you should rectify it. If we write a judgment, then we'll have to go into many aspects. And then because the judgments become a precedent,
Lordship.
the precedents will be followed, then it will create
Difficulty, Lordship.
These are the things I would want you to communicate to your officers.
Lordship, that has been already communicated. I am just waiting for the, Lordship will wait for 2 more weeks, Lordship, after that.
No,
Lordship will
that
pass.
can be done. That
Lordship.
can be done. That can be done, but the only thing is in the court, if a petition is filed asking legal questions, the judges will have to answer it by a judgment on legal points.
I understand.
We can't do anything about it.
Lordship.
So it is for you to take a remedial measure, rearguard action even now and close it this way, that way, because these people have been working for long,
Lordship.
working for long. We can provide for some remedy in the order if you agree.
Lordship, I am convinced, Lordship.
That will take care of, after so many years of reopening these issues, then we pass a mandamus, when you find it difficulty in
Lordship.
implementing it, then contempt will come, and these are not taking us anywhere. These are not taking us anywhere.
Lordship.
We can do a new beginning, but whatever problems were there, that has to be rationalized. If you find something is totally fraudulent or somebody has done something in an illegal manner completely, then of course the matter is different.
Lordship.
But if there is some slip here, some slip there, some order, some communication not reaching in time, some approval not reaching, but otherwise it has the trappings of a regularization, then what options do we have?
Lordship.
So please sensitize your departmental authorities also.
I will
that,
convey that.
these things have to be, you have to have a problem solving approach.
Lordship.
A problem solving approach is also the need of the hour.
Yes.
Just by delivering judgment after judgment after judgment, many times we may not be able to reach out. Of course, as judges, this is our job. We have to hear cases and deliver judgment. But there could be better ways of addressing things sometimes. Explore it,
Lordship.
provided it is within the ambit of law. We are not going to go an inch here and there. It has to be completely within the confines of law. Anything fraudulent, anything which is started with a dishonest, means, that too we cannot approve. But if there is some irregularity here or there, maybe you should look at it instead of pursuing these litigations. We are consuming time of the court. After so many years, whether the executive engineer took the approval in the due process or not, you want us to go into that, call for the records, bring him, take action. What purpose does it serve?
Lordship will pass an
You
report
wait.
on the next day. Lordship.
You wait for another 1 year? No.
My lord, he was 50.
6 months, 2 months, 1 month?
Immediately
Let
after,
him,
immediately after my holy vacation.
let him have some time. If they resolve it, then your job is done. What is your problem? Nothing is going to change. Heard Mr. Ayed Sekel and counsel for the writ petitioner. Also heard Mr. P. Nayak, Lanet, standing counsel, PWD, is it?
Lordship. Lordship.
Assam appearing for the respondents who seeks further 4 weeks time to obtain instruction in the light of the last order. What is the date of the order? In the light of the order dated?
Last order.
Order dated so and so passed by this court. Order dated 14/2/2023 passed by this court. So on the request of Mr. Nayak, this matter is directed to be posted again on 31st of March 2023 as a fixed item. Mr. Nayak, I believe you have understood
I will try
the
it.
query.
I'll definitely.
See if it works out. Otherwise, we'll do our job.
Lordship.
But if you do it in a concerted manner, it will be better for you.
Lordship, I will try. Oblige. Oblige.
Item 18. Item 18. Sorry.
May it be the lordship. It was substantially hard, my lord. They were directed to file an affidavit.
Lordship, I don't have much role in this matter. I'm the state central government. Central government study council next to me there.
No, he's not there.
They were supposed to file affidavit or
Yes,
something.
they have filed
They
it.
filed an affidavit.
What is the affidavit date?
Affidavit. 24 24th February. Although it was directed to be filed within my lord 14th of February. It was filed on 24th of February.
Filed on 24th February.
Yes, ma'am.
But I said recorded.
It is not there. Yes,
Huh?
that's why requisition has been given.
Oh, affidavit is not.
For
there.
Lordship can see, my lord, because
Affidavit
only they have
I-1 hai.
enclosed.
The affidavit has not yet reached.
Yes, that's why I have mentioned requisition has been given. But
We'll do it. We'll ask him to take it with the record and
At
have
2
it on
o'clock,
Thursday.
at 2
No, no,
o'clock.
not 2 o'clock, not possible today. The court is rising earlier. Thursday. You're coming on Thursday.
Thursday.
Ms. Ann Sekel, any counsel for the petitioner is present. The departmental counsel submits that an affidavit filed on behalf of, affidavit was filed by
On behalf of Union of India,
Union of India on, what is the date?
24th of February.
24th of February 2023 is not on record. First up, since the affidavit was filed as per the leave granted by this court, hence perusal of the same would be necessary. First up, in view of the above, registry to list this case again, day after tomorrow, what is the date?
Second March.
2nd March 2023 as a fixed item by tagging the affidavit with the record of the case.
I'm like.
We'll finish it on the next day. No adjournment
so.
on that day. Yes.
Only thing, my lord, I have got other cases also. If need accommodation, your lordship will kindly.
All right, all right.
Apply.
So petitioner was a constable in BSF.
Hmm.
And summary security proceeding, my lord, I have been dismissed from service. My lord. My contention is purely legal, my lord. Considering the charge, my lord, charge is under 46. There is a clear mention in the rule that if the charge is under 46, summary proceeding is not applicable.
46 of,
46 of the act, my lord, BSF act, my lord.
let us see, the act is there. Have you given the list of books?
Only BSF, other decision I am not relying on.
Yes, what do you say about that?
My lord, regarding that, my lord, in the affidavit, we have denied that point.
Oh, forget it, come to the point. Regarding that affidavit was filed, affidavit was in green paper. I'm not asking that. What is your response to his
My
plea?
lord,
Summary proceeding cannot be resorted
my
to.
lord, in that, with that point, my lord, I have to, my lord,
Oh,
and my lord, and regarding one fact is that, my lord,
no, but that is the main point. When the matter is listed for hearing and the court asks you,
my lord,
then you say that you have to look into it.
no, my
What
lord,
have you done then?
in the affidavit, my lord, we have denied that point, my lord, categorically.
All right, so
My
that's your stance.
My lord.
All right, then we'll see and dispose it of. Yes, which is
My lord, the
section,
charge sheet, lordship will find page 40, my lord.
section 46, is it?
46, my lord. Rule, my lord. Rule 47, my lord.
Rule 47. Charge not to be dealt with summarily. Okay, what does it say? A charge for an offense under, please read 47.
No, I'm coming, sir. 47. A charge for an offense under section 14 or section 15 of the clause A and B of section 16 or section 17 or the clause A of section 18 or clause A of section 20 or clause A of section 24 or section 46 other than for simple and hard or theft or a charge for abatement of an attempt to commit any of these offences shall not be dealt with summarily. Except for minor thing, my lord. Here, the allegation is that I have taken money while posted, and section 7 of the special, my lord, Prevention of Corruption Act has been attracted, my lord. 46, your lord.
Section 7 of the PC Act.
PC Act, my lord. That's why 46, my lord. 46 of the
So
Act.
PC Act, then it has to be
No,
put
my
up for
lord,
trial.
any offense committed by BSNL personnel regarding some IPC or other act is considered civil act. And that can be tried by BSF court only. But that is considered a civil act under 46. Now, Lordship, can you see the charge sheet for a moment, my lord, page 40.
Page 14. Yes.
My lord, committing a civil, my lord, first charge is BSF Act 1968 under section 46. Right side, my lord, committing a civil offense under section 7 of the Prevention of Corruption Act, being a public servant, obtained for himself any gratification, whether other than legal remuneration as a motive or reward for daring to do any official act. On so and so, at about so and so, while the OP duty, ex-BOP so and so, 17 Battalion BSF had allowed to cross 5 numbers of cattle from India to Bangladesh during his OP duty from 6 to so and so in connivance with smuggler or 29,000 so and so only. So 46 is attracted, my lord. And the second charge, which is the minor charge, my lord.
Yes.
Second charge, my lord, neglect to obey local order. My lord, as per the instruction, my lord, a person posted on duty must not have more than 500 rupees in his with him. Here, my lord, the allegation is that 1,000 was recovered, but not on the day of occurrence, on the next date, my lord. So these charges on the face of it, my lord, not maintainable, because this 1,000 was recovered from the next day when I was not in duty. Charge number 1 is the major charge, my lord.
29,000 rupees was found in your possession.
No, my lord. Lordship, kindly go to the fact, my lord. It is wrongly stated. Witnesses say, my lord, only 1,000 was recovered, and rest amount was recovered from my quarter, from my baggages. Ransacking my bag, my lord, that was found in my bag. That is the.
So what
1,000 was
what was your explanation?
My lord.
Where did you get so much money? What was your explanation before?
My lord,
First
my lord.
explanation. What was it?
Explanation is not there, my lord. Explanation is not there.
Then
A summary procedure, actually, there was no scope to do anything, my lord. One day.
No,
Lordship,
but in
kindly-
the writ petition, have you explained?
No, my lord, that part we have not done.
Then
But basically, we are saying, my lord, this being so much a serious charge, my lord, you cannot hold a summary procedure, my lord. And Lordship, kindly see the impure order. Not a single word reason finding, my lord. Lordship, kindly see for a moment, my lord. Page 43.
Page 43.
How I have been dealt, my lord. Lordship, kindly see, my lord. Charge 1 is number 1 is recited, 2 is recited, and last line. This is the order, my lord. The court sentence accused so and so to be dismissed. As per Supreme Court citation, my lord, reason is not to be given, my lord. In a BSF matter, my lord, reason is not to be given, but the act says that finding that I am guilty or not guilty, that has to be recorded. That is the, at least that is to be recorded that I am found guilty regarding charge number 1. I am found guilty regarding, there is nothing, no mention, my lord. It is not even mentioned that I found guilty regarding charge number 1 or 2, nothing, my lord. Severe punishment they have imposed upon me, my lord, without following the minimum procedure.
So which provision permits summary dismissal without holding an inquiry?
That is there, my lord.
Which is the provision?
My lord.
Is it akin to Article 311 2B?
No.
Provision?
That is not, because they, summary proceeding, they can summarily, they can hold.
All right,
But as I have pointed out, my lord, of this charge, my lord, they cannot hold, my lord. Because this charge consequence is dismissal or maybe some severe, they cannot hold it.
So that is because of 47.
47 of rule 47, my lord. Small punishment, they can do like that, my lord. There is a specific legal bar. My lord.
So 47, could you please repeat why you are saying this cannot be done? Which part of 47?
47 of the rule, my lord.
Yeah, rule 47, which part of it comes into play?
My lord. Charges not to be dealt with summarily, as you also got it, my lord. My lord, a charge for an offense under section, these sections are not applicable, my lord.
Hmm.
Lordship will kind, or section 46. Has you lost third line, my lord?
Yes.
Other than that of a simple hard or theft. If it is simple hard or theft, it's a different thing, my lord. Otherwise, or a charge of abatement of an attempt to commit any of these offences shall not be dealt with summarily. All these sections mentioned, my lord, giving an exception, my lord, if it is a very petty thing, otherwise 46 is not mentionable. 46 cannot be tried summarily.
So what is section 46?
46, my lord, doing civil offense. Civil offense, my lord, subject to the provision of section 47, any person subject to this act who at any place in or beyond India commits any civil offense shall be deemed to be guilty of an offense against the act, and if charged therewith under this section shall be liable to be tried by the security force court, and on conviction be punishable as follows. 48 gives the punishment which includes dismissal, my lord. Here the civil offense was violation of contravention of section 7 of Prevention of Corruption Act.
And how does one know that this civil offense would include offense under PC Act? No, it is your submission that civil offense will mean these things, but that is not mentioned in section 46.
46 is mentioned, my lord. Lordship kindly see, commits any civil offense shall be deemed to be guilty of an offense against the said act. And any civil offense.
So that's what I'm asking. Offense under PC Act is a civil offense within the meaning of this act. How does one figure out that?
Maybe in the definition, my lord. The offense is correct, my lord.
Oh, maybe you have not seen it.
Civil offense. My lord, D, my lord, 2D.
2D.
Civil offense means an offense which is triable by a criminal code. This is submitted, my lord. Any other criminal offense being done under any act that is considered as a civil act, my lord. Civil offense.
All right. So then if it is set aside, then according to you,
My lord.
what would be the way forward then? They can start a fresh proceeding.
They can do it, my lord. They can always do it, but that liberty may be left with them, my lord, if they are.
My lord, one thing is that my lord, this person, my lord, earlier, my lord, prior to that, my lord, 5 punishment he has gone, my lord, within the span of my lord, 8 years, my lord, and this is the 6th time, presently, my lord. And in this process, he has confessed. My lord, regarding the technicality, my lord, yes, my lord, he confessed his guilt, my lord. And
Where is the confession?
my lord, before the authority, my lord, is that I need money.
Where is the record?
Record, my lord, today not available.
When will you give the record?
My lord,
After the judgment is delivered.
no, my lord, actually, my lord,
Mr.
yes.
Parasar, what is this?
No, my
happening?
lord, earlier, my lord, record was called for, yes, my lord. I am saying, I have already informed him, my lord, record was called for in the 2021 order, my lord. And they kept the record, when the case listed, they provide the record. Yesterday, I got the record, but I have seen, my lord, it's, my lord, 2011 to 13, my lord, earlier suggest, my lord, this present file, my lord, they have wrongly, my lord, given the present file, my lord. So, my lord, actually, the main record is not available.
Where is the confession?
One, yes, that part is not, earlier PT offense is in this file, my lord, record, that record is not available.
Is there any admission on his part?
My lord, I have found some record, my lord, admission part is there, my lord. Before the commanding officer,
Yes, admitted.
my lord, that in spite
When
of
the admission is there, what is where is the scope of holding an
they
inquiry?
held their proceeding, my lord. Their proceeding has to be held, my lord. Confession regarding there is a guideline given, total guideline given in.
No, but do you have the admission? You don't have it.
My lord, that's the record, my lord.
Get the record. Let him get the record. If the admission is there, and there is no need to record reasons. Then the
I'm
matter
not
will
saying,
be-
my lord. Reason I'm not. I am saying that if it is a charge is 46, my lord, summary procedure cannot.
Where is the expression summary procedure? Have they used that expression?
Yes, my lord. Summary procedure court, my lord. They are
Summarily dismissed,
Yes,
they
my
say.
Summarily, that's your lordship read the.
No,
reviewed
that's
order.
correct, but the court has to know why you want an inquiry to be held. We can't just, you see, merely because some technical law has been violated. Supposing you have admitted that you have not questioned the admission, then what for? Even if an inquiry is held, your admission will be taken note of and you will be thrown out.
Rule says, my lord, even there is the admission, my lord.
No, but
Then proceeding has to be held.
those are hyper technicalities. Those are hyper technicalities.
Your lordship, can the commander and everything, I mean, constable, in what situation that was extracted? I have denied it.
29,000 rupees found in his possession. He could not explain. He admitted of his.
Because of his father's illness, they need money.
So after that, technicalities will have to be interpreted in the facts of the case. No?
Well,
So what is that? Why should it be sent? So that he can now resile from his admission and say that, no, I have not taken. That will not allow. So whatever is already on record, you have to show us that even if these are taken into account, still if an inquiry, a regular proceeding is held, this is what he would be able to prove. Unless you do that.
no, administration before administrative authorities, the lordship knows, my lord. Constable is absolutely.
Have you denied? Have you said that
Repetition have denied, my lord.
by force admission?
Yes, sir, repetition we have said it.
Let us get the record then.
Well,
Mr. B. Chakraborty and counsel for the petition.
part of, my lord.
It will come, why I'm not going anywhere. Mr. K. Parasol and CGC submits that there is an admission on the part of the petitioner, but since the entire records are not available with him, he is unable to place the same before the court. In view of the above and on the request of Mr. Parasol, this matter is directed to be listed again on 21st March 2023 as a fixed item, so as to enable him to obtain the records.
Item 28.
May it please the Lord. Well, it's the petitioner before your lordship.
This is a what, parted matter?
No, my lordship, it's not part of it.
Some court had heard it earlier?
No, my lordship.
Just a minute, please take your seat, just a minute. So some affidavit has been filed.
Yes, my lord.
When was it filed?
In the month of March, my lord.
And have you filed any rejoinder? Not required.
Not required.
Hmm.
Facts are not very elaborate. my lord.
All right.
Law point involved.
And who is appearing for the other parties? You are for?
And for respondent number 1, 2, and 3, my lord. For the mines and minerals, my lord.
And Mr. Bora, you are for?
And for the personal department, you worship, phone number 4,
And who is appearing for 5?
finance department. The fact is, your lordship, on previous occasion, the records, cabinet note regarding the passage of the OM of March 2015 was required. Actually, I've got the records just now, actually. And earlier I had the photocopy of those records, because these records were actually submitted in relation to WPC number 657 of 2017. And that particular writ petition was closed because the petitioner therein had expired. So these records were somewhat difficult to trace all this, and right now, only just a few moments back, actually, I got this record. I have to actually go through these records, this whole bunch.
My lord, the predicament is, my lord, the petitioner already retired from service, my lord. Last year, 31st of January. She has given in 28 years of service, my lord. Similarly situated persons were regularized pursuant to that OM, but on a wrong interpretation of the OM, my services were not regularized. Because I was
Retired
appointed
as what?
assistant geologist, my lord. I was initially appointed in the year 1993 as a 3F employee against the regular sanction post, my lord, along with the other 2 persons who were junior to me in merit, my lord. So thereafter, my lord, in the year 2015, there was an OM, my lord, maybe pursuant to the decision in Umadevi. There was this OM wherein, my lord, the OM said, my lord, because there were a lot of 3F employees who've been continuously working, and by now they have crossed the age limit to appear before the APAC. As a one-time measure, we'll be regularizing all of them. Consequently, my lord, the other 2 similarly situated persons, they were regularized, and I was left out. The reason for the reason why petitioner was left out was because they have come with a very silly objection, my lord, that I did not appear before the APAC. Had I appeared before the APAC, I would have been regularized. Now, my lords, the other 2 similarly situated persons, they were regularized on the strength, my lord, that they appeared before the APAC, my lord. Now, what had happened, my lords? The other 2 similarly situated employees, my lord, in the year 1993, after they were appointed as 3F employees, my lord, after they were appointed as 3F employees, there was this interview process for regular selection. Now they appeared before the APAC in the year 1993, and they were not even selected, they were in the waiting list. They were in the waiting list. Now, lordship is aware, my lord, a select list can be valid only for.
So who are they? Who are they? They are not parties here.
Not parties. I'm not claiming, there's no claim against the claim of the petitioner against them. I'm on the ground of equity, my lord.
Yes.
Yes, my lord. Both of them, since they appeared in the year 1993 and they were unsuccessful in the regular selection process, but nonetheless, there was a selection list wherein their names.
So petitioner is not getting any pension.
Nothing, my lord. Nothing, my lord. Nothing.
How many years she has served?
28 years, my lord.
Without any break.
Without any break, without any intervention of the court. Only intervention was pursuant to filing this writ petition in the year 2016, after the department had, in the year 2019, after the department came to learn that a writ petition has been filed, she was not allowed to discharge her duties. Therefore, we filed an interlocutory application, and there's an interim order to that effect which says my services should not be dispensed with. But since 2016, I've not been receiving any salaries, my lord. Well, it's they have totally misinterpreted the OM, my lord.
Where is the OM? Let us see.
My lord, we'll come to page 26, my lord. May I read,
26,
my lord?
26 of the read petition.
Read petition, Annexure
Yes.
5.
Yes.
The first few paragraphs are very important, my lord. It's 16th of March 2015.
Yes.
Appointments under Regulation 3F of APSC Limitation of Functions Regulation as one-time measure for regularization of certain such appointees. Various departments of Government of Assam from time to time exercising power under Regulation 3F of APSC Limitation of Function Regulation, henceforth referred to as Regulation 3F, gave appointments to various candidates to tackle emergency situations faced by those departments. Many such candidates, initially appointed for 4 months under the regulation, are continuing in the services year after year in ad hoc manner without regularization. All these candidates have already, this is very important, my lord, all these candidates have already crossed the upper age limit specified for appearing in the interview test held by APSC for the post that they are holding, and therefore left with no chances to get regularized in the post. Evidently, this situation has arisen mainly due to unwarranted exercise of power under Regulation 3F by the departments, failure on the part of the APSC to hold interviews in timely manner, and also the failure on the part of the departments to move APSC for regular recruitment. As communicated by the concerned department, all these Regulation 3F appointees now under consideration are working in regular vacancies, mainly under various orders of the High Court, and drawing their regular salaries as admissible. My lord, the next lines are in conflict, my lord. However, those cases where the incumbent concerned have not appeared the APSC test stroke interview, and those whose cases are sub judice are outside the purview of this OM. Your lordship would see, my lord, this 3 lines, my lord, it totally negates the object of the OM itself, my lord. The OM says, my lord, we are, as a one-time measure, will be regularizing those people who have given so many years of service, and now they are not, the age, my lord, they have already crossed the age limit to appear before the APSC or to sit in an interview. Now, the paragraph here, my lord, it totally negates the entire object of the OM itself. It is because of this, my lord, taking the handle, my lord.
So which is the offending part according to you?
My lord, however, those cases where the incumbent concerned have not appeared the APSC, test stroke interview, and those whose cases are sub judice, I'm not concerned with that, my lord, sub judice, are outside the purview of this OM.
So your case was sub judice on that day?
No. Lordship would read it together with paragraph number 2. It says, I'll read it again, my lord. All these candidates have crossed the upper age limit specified for appearing in the interview test held by the APSC for the posts that are holding, and therefore left with no chances to get regularized for the post that they are holding, and therefore left with no chances to get regularized in the post. Now, my lords, with all due respect, my lords, this phrase, my lord, not appeared the APSC.
Where is our date of appointment?
Has to be read down, my lords. Date of appointment, page number 19, my lords, Annexure 1. It's dated 1/2/1993. I am at serial number 2, 3 and 4. Below me, they were regularized.
You're at serial number?
Serial number 2. Anusia Paul Basu.
So what has happened to 1, 2 and 4?
Well, 1 must have, one was superannuated, I'm not aware, but 2 and 3 and 4, my lords, they were regularized. The order of their regularization is at page 26, pursuant to the OM. Now I'll show your lordships why they were regularized, my lords. 26. I'm sorry, 20. My lord, 25, my lord. I'm so sorry. In pursuance of the Personal B Department's Office Memorandum dated 16th of March 2015, the Governor of Assam is pleased to regularize the service of Sri Pallab Kumar Barua and Sri Prakash Bora, assistant geologists, who've been serving under Regulation 3F of APSC, since 1st December 1995, under the Directorate of Geology and Mining, Assam, with effect from 16th of March 2015, with the following conditions. Now, they were regularized. The reply of the department, why they were regularized, the reasoning, your lordship would find in the additional affidavit, my lords.
Additional affidavit filed by?
The affidavit in opposition, my lord, filed by the respondent number 3. They say that I did not appear before the APSC, which in my humble submission is not a requirement under the OM. My lord, will come to page number 8, annexure 1. When representations were made by the petitioner for regularizing her services, the file was moved in the department. It's a copy of the office note, my lord.
Page number 8, annexure 1 of the rate petition.
Of the, my lord, the affidavit in opposition filed by the respondent number 3. It's dated 13/6/2019. Sworn by Mr. G.S. Panesar, ACS.
Yes. All right, page number 8.
Page number 8, my lord, the office note. Mines and Minerals Department. May I read, my lord?
Yes.
Your endorsement above. Since both incumbents, namely Shri Pallab Kumar Barua and Prakash Bora, were recommended by APSC, though in the waiting list, a relatively lower position, their cases for regularization through cabinet approval as proposed may be considered, and there appears to be no bar in that. So far, the cases of other incumbents, namely those who failed to pass examinations held by APSC or those whose posts have not been advertised, are concerned, legality of their regularization by way of cabinet approval needs a closer examination, since dispensation of APSC consultation may not be permissible. While Srimati Anusia Paul, she is the petitioner, not having been recommended by the APSC, her case cannot be considered. Now they say I have not appeared before the APSC, that's why my case cannot be considered. The lordship would see.
Factually, that is correct.
Yes, actually that is correct.
But the other two have appeared.
93, my mother was sick, there's a pleaded case, but the other two have appeared. Lordship would see if that would survive. My lordship would come to page number 10. Some selection held in the year 1993, wherein the other two persons were in the waiting list, not even in the recommended list, my lord. They took recourse to that select list pertaining to 1993 and regularized their service in the year 2015, saying that they have appeared. So they have appeared, they have failed. Lordship would see page 10.
Yes.
Shri T.K. Bora, IS retired, chairman in charge, Assam Public Service Commission, to the Secretary Government of Assam. Recruitment to the post of assistant geologist in the office of so-and-so. 38 candidates were interviewed by the commissioner with the help of experts deputed by the government. The merit list of general category includes the members of reserve category, namely OBC candidates. These candidates have been considered on general candidates on competitive basis according to government circular so-and-so. The following candidates are recommended. The list of 11 recommended candidates. Lordship would turn the page kindly. The commission has recommended following name against future vacancies in waiting list, which may occur during the period of validity of the nomination in order of preference, as serial number 2 and 4. The other two persons, my lord. They were in the waiting list for some selection in the year 2003. Supreme Court is clear on that point, my lord. Validity of a select list in the absence of any rules can be only valid for a period of 1 year. So taking recourse to this selection.
And where is the order of regularization?
That your lordship will find in the writ petition, page number 25, my lord. I say, oh, sorry, Manoj.
Then did your client file any representation?
Yes, lots, my lord. In fact, the department themselves on various occasions represented before the secretary of the department, saying that she has put in so many years of service and her service is also indispensable. Kindly sympathetically regularize her service, my lord. Even in the additional affidavit, my lord, I'll come to there are number of representations by the department themselves. I represented, there are representations where I represented. So in fact, the government has regularized on the strength of that OM a number of other persons from the other department. Somehow, the department Mines and Minerals, they thought, my lord, that since what I've shown in the OM, since it says, my lord, one word, one phrase, appear before APSC, they thought it's a mandatory criteria, my lord. But I say, my lords, if that has to be construed in such in the manner construed by the department, it would render the entire office memorandum OTOs, my lord, and nugatory. There has to be a purposive interpretation to the office memorandum. The office memorandum itself says that it is for people who have already crossed the age to appear for any test or interview before the APSC. Now, my lords, I am covered by the OM and I'm also covered by the judgment rendered in Uma Devi and ML Kesri. Uma Devi and ML Kesri, my lord, specifically says that on that cutoff date in the year 2006, if I have rendered more than 10 years or more service against a sanction vacant, against a sanctioned post, then I'm liable to be regularized as a one-time measure. Now, they don't say that I am an illegal appointee. They don't say that I'm not working against a sanctioned vacant post. Two similarly situated persons were regularized, and Lordship has seen on the strength of some nomination in the year 1993, which must have lost its effect in the year 1994. After more than 11 years, taking recourse to some selection where they were in the waiting list.
All right. So anything else?
My lord, may I show your lordships the recommendations of the department?
Yes.
My lord, first, page 29, my lord.
Page 29 of?
29 of the writ petition, my lord.
Yes.
I won't trouble your lordship, my lord. The third paragraph. It also appears that she is an MSc in geology with first class and attended annual geological field programs as well as government training programs from time to time. In view of her long service of more than 22 years in the directorate and adequate experience, she deserves to be regularized in her service immediately, even in relaxation of the existing provisions of the department for such regularization. Thereafter, my lord, your lordship turns the page 30. Again, my lord, this is by the director of geology to the joint secretary, mines and minerals. The last line would suffice, my lord. Under the above ground, I would like to recommend her service. Thereafter, my lord, my representations at Annexure 8, Annexure 9, and my lord would lastly come to my lord's page 41 for a moment, my lord. This is to show that others are also regularized on the strength of that OMs. Page 41. Here the requirement for appearing before the APSC is absent. In person to the government OM, so and so, dated 16/3/15, the same OM, and after proper examination, verification, and pertaining to the eligibility in terms of education and other qualifications as required at the time of their initial appointments in regard to the post they are now holding, the services of the following subject teachers and demonstrators who were appointed under regulation 3F of the so and so are regularized against the post they are currently holding with immediate effect. Assistant teachers 38 in numbers were regularized on the strength of that OM. and it does not speak about any appearing before the APAC or any concurrence of the APAC. Thereafter, my lord, there is one additional issue, my lord. There was the last extension, which is at page 22, was for a period was till 31/07/2016. Now, what had happened in this 28 years of service, the extensions always came ex post facto, my lord. For example, my lord, even if I have completed the tenure, there'll be an order saying from with effect from that day to this day. So thereafter, my lord, the last extension was till 31/7/2016. However, my lord, thinking that it will be again extended, I was working in the department, my lord, but I was not paid this paid salary, my lord. Therefore, 2019, I filed the present writ petition with twofold prayer, my lord, that my service should be regularized and I should be paid my salary. Now, after I filed the writ petition, like I submitted before, my lord, I was not allowed to attend the office. However, my lord, pursuant to filing an IA, there was an order which says that my services should not be dispensed with. But thereafter, I kept working in the department. Now, what the department in their affidavit in opposition, what they try to say, my lord, they have said that from 1/8/2016, I have not attended office. But however, my lords, would kindly take up the writ petition for a moment. They do not have any explanation for this, my lord. Lordship would come to the writ petition, only a few pages, my lord. Lordship would come to page 45, page 44 first, my lord. This is 2015. Lordship would turn to page 45. I'm sorry. It's dated 29/11/2016. It's an office order.
Yes.
It is after 1/8/2016. Please find here with the list of officers nominating for the work of District Mineral Foundation Trust. The officers are hereby requested to perform their duties on the District Mineral Foundation Trust as on when needed by the concerned Deputy Commissioner besides their normal office responsibilities. There's a list, my lord, on the next page at serial number 23, the petitioner, that she was assigned duty. Thereafter, my lords, page 47, another order assigning her duty. This is dated 24/12/2016. Page 17. I'll just read the first line. Please find here with the field program of the Directorate of Geology and Mining. Lordship would turn the page. First, my lord, B, groundwater. The right column, my lord, the right column, personnel and equipments, Srimati Anusia Paul Basu. Again, on December 2016, I was assigned duties. Now, they don't have any explanation for that, my lord. Then page 49, 2017. 7/7/2017, page 49. The following officers are hereby entrusted with respective committees for performing duties in connection of so-and-so meeting, which is scheduled to be held tentatively in the third part of July 17. The venue will be fixed later on. Lordship would see serial number 2, preparation of folder material, clause D, Srimati Anushya Paul, Assistant Geologist. And last, my lords, page 51. This is by the Mr. G.S. Panesar, my lord, who has filed the affidavit, who has said that she has not attended office after 2016. It is his own letter, my lords, 2017. Please find here with the field program. If your lordship turns the page, project 3, the right column, Anusia Paul Basu, my lord, 3 names, personnel and equipment. He himself has assigned her duties. Now, in their affidavit, they say, although she didn't come, but sometimes we assigned her duties. So that is logically cannot be, my lord. If a person doesn't attend office from 2016 till 2017, regular basis, you've been assigning her duties.
Yes.
And my lord, one last, my lord. Lordship may kindly take up my additional affidavit, my lord, filed by the petitioner.
Additional affidavit filed on
filed by the petitioner on 18th of November to 2020.
yes.
My lord, would take up annexure I, page 5. The running page is 77.
Yes.
Page 5. This is by the Director of Geology to the Additional Chief Secretary, Government of Assam, extension of service in respect of Srimati Anusya Pal Basu. I'm submitting here an application on so and so, so and so. Service of Srimati Anusya Pal Basu has been extended up to so and so, dated 2nd June 16. Considering her long service experience, this office again recommend for extension of service. My lord, to see the last till 2/30/11/2020. This is for your kind information and necessary action. Even the department, my lord, time and again, they've been writing to the, rightly so, my lord, she's a first class MSc, duly qualified, due to the fault of the. I'm sorry, my lord, I'm not troubling your lordship going through the regulation 3F, my lord. And 3F also does not mandate you have to appear before the APSC. my lord.
This officer is still in service.
But she retired on.
No, the one who filed the affidavit. Director who
Yes, sir,
filed the
yes, sir.
affidavit.
My lord, I think not in service, perhaps.
Not in service. Yes, what have
My
you got to say? First, before you say anything. Please throw some light on this order. That order where their presence have been marked. The other candidates,
My lord,
order of 1993.
my lord,
Where is it? Which page is it?
my lord, that is starting page 19, my lord,
1993, there is an order, no?
19 page, my lord, page
Huh?
19, 19.
Page 19, yes.
Order dated 1st February 1993.
So that is by which 4 persons were appointed under 3F.
Here,
Then the 2 candidates, namely,
Pallab and Prakash.
yes, they were found in the waiting list.
Right.
Where is that?
My lord, that your lordship, my lord, would find in the affidavit filed by the respondent number 3, page number 10. Page number 10. Affidavit in opposition.
Yes. So this 2nd September 1993, this was in response to which advertisement?
1993.
Yes. The records are here.
These are personal department records.
You have which department record?
Personnel.
But then APSC is a party here.
No, my lord, the case is not a party.
Then what to do? How do we proceed?
Well,
We would like to know at page 10, 2nd September 93. This has been taken as a basis to regularize the other
Yes,
respondent.
yes, no,
This was in response to
this
which
was an
advertisement?
advertisement for the post of geologist. They were, my lord, some post of geologist which was advertised. by
When
the-
was it issued?
The advertisement, my lord. Date of advertisement must be, my lord. Maybe after the.
Do you have the copy of the advertisement?
Look, this is a select list for a regular selection process.
For which post?
For assistant geologist, my lord, post of assistant geologist.
When was the advertisement issued?
Competitive basis according to government circular.
What is DHM?
Director of Geology and Mines, or DGM.
DHM is Directorate of Geology and Mining.
Recruitment to the post of assistant geologist in the office of DGM.
Correct. So this does not refer to any date of advertisement.
No, my lord, no. These two persons, my lord.
You also don't have that. You don't have that.
I don't know. But I have a I made a statement, my lord, that.
Statement
Yes,
is another thing. That this advertisement was not, when was it issued? You don't know anything.
I didn't participate, but that's,
Huh?
I didn't participate in
Of course,
this.
you didn't participate, but you are relying upon this, saying that this could not have been the basis.
Yes. they
How
have
do we appreciate your argument unless we know what was the basis of this list?
But since the affidavit was filed by them, I have made a reply to the affidavit. Saying, my lords, that 1993, there was a selection process, but I didn't appear, I couldn't appear because I had to attend to my mother.
Then we cannot go into all those aspects. I cannot write a judgment in darkness.
In any
Neither
case,
APSC is a party, nor these things are there. These things you forget it. These are all gone. Because you should have implemented the APSC at least as a party. You are questioning this notification of 2/9/1993, or rather the reliance placed on this. So whichever way you look at it, we have to know what was the basis of this notification, is it not?
This issue came to light only after my friend filed the affidavit. That they, but in any case, if I may humbly submit, my lord, a select list of 1993 cannot form the basis, my lord. I've come up with judgments. Because validity of the select list would be only for a period of 1 year. That's the first issue, my lord. Second, my lord would kindly consider the office memorandum.
Let him answer, yes.
And I'll place the judgments, my lord.
My lord, basically, my lord, we have filed our affidavit taking the stand. In paragraph 6, that so far these two persons have concerns, which has been regularized, my lord, that is based on, my lord, their affairs before the APSC. In paragraph 6.
When were they regularized?
My lord, their job was regularized, my lord.
15, my lord.
List is there, my lord, in read petition.
2nd of May 2015.
2015.
And that was done on the basis of their inclusion of their names in the vetting list of notification dated 2nd of September 93.
My lord.
Is it permissible?
My lord, basically, my lord, paragraph 6, we have stated that the ground that we have taken, my lord, sole ground is basically, my lord, that here it is that Anusya Pal neither applied to APSC nor appeared for interview placing before the Honorable Cabinet. The of the Judicial Department was obtained and the views are as follows. Since both the incumbents, namely Pallab Kumar Borua and Prakash Borua, were recommended by APSC, although in the wait list relatively lower positions, their cases of regulation through cabinet approval as proposed may be considered, and there appear to be no bar in that. So far, the case of other incumbent, namely those who have failed to pass the examination held by APSC or those whose posts have not been advertised.
No, Mr. Chamaria, you see, just by saying anything will not work. 93 process could not have been the basis of regularization in 15. If you are relying upon that, then we'll have to set aside everything, even their regularization. What to do? And second thing is, she was getting a pay scale. She was drawing her salary, so many years of service.
2016 period.
Yes, she was drawing her pay scale, no? So therefore, perhaps a very shabby treatment was meted out to this writ petitioner, we feel.
But question is that, my lord, since 2016, she has not been allowed to, my lord, join, my lord.
Why?
My lord,
Why?
reason behind is that, my lord, because earlier it was extended, my lord, from time to time, but after 2016 it was stopped on the basis of the recommendation by the personal department, my lord. Because the issue which has been dealt with by the department about its regulation that has been declined on the strength of, my lord, opinion given by the my lord, judicial department, my lord. Therefore, my lord, ultimately thing is that, my lord, since her case is differentiated from the point of view of, my lord, two other candidates, my lord. My lord, she may not be entitled to get the regulation, my lord. Because, my lord, in such a,
very difficult to accept this.
such a situation, my lord, the regulations that OM, which otherwise, my lord, come into play, my lord, no doubt, my lord, about APSC examination, that thing is absent. My lord, the treatment that has been given to the alike other candidate, that was the sole basis APSC, my lord. The APSC, my lord, since we failed to appear, and there is no reason assigned why she failed to, my lord, appear for APSC examination, my lord, before the, my lord, department. That particular facts are taken into consideration, my lord. And other thing, my lord, normally, my lord, some recommendations come, a representation that is another issue, but since there is a bar at that point of time, my lord. That is, my lord, the stand we have made.
No, but 93 to 2015 is around how many, 23 years?
Yes.
was it?
20, more than 20.
How can we have a temporary employee for 23 years?
Good.
If you need the services of someone for
My lord.
23 years
My lord.
or 22 years,
Right.
does it not mean that the service of that person, let us accept your argument. Your argument that her post was not.
My lord, the thing is that while this note was, my lord, the place, this is only on the strength of, my lord, the issue pertaining to APSC, my lord. So far the OM part is concerned, my lord, this note nowhere reflects, my lord, the effects of OM. Therefore, two treatments are
Mr.
there.
Samaria, if we write out a judgment, there will be a cost of 10 lakh rupees to be recovered from the salary of the officers. Keep that in mind and make your arguments. If we allow it, 10 lakhs cost, it will come with that. Well, this kind of treatment is not acceptable. You have used the service of someone for 22 years. And after that also there are documents to show that she was assigned duty from time to time. How can you do it if
And-
she's out of service?
Lordship have put a
So
question
if
about.
you are just making the judges work just because you don't care,
Right.
we will also make you work so that you start caring. We are not sitting here to deal with everything that is thrown to us. If you find that these are all created trouble, then there has to be a signal sent. Your officers cannot be so casual. How can the process of 93, a list, wait list, be used to regularize somebody's service in 2015? Do you think this is a joke? Which service law, which decision permits that? You think it is a joke? We are sitting here that anything you say, we'll have to hear you and pass a judgment. What is this all? What are all these things? You are recruiting people under the same process, same post,
Man.
allowing them to work. At least 2015 till 2016, you don't disagree that, deny that she was working. After 22 years, you suddenly tell her that we don't.
My lord,
want-
second aspect is very important, Lord. Can I say that while this note was placed, my lord, that note was on 29/5/2015, and that OM come into play, my lord, later on, my lord. That's why that is 16 March 2015, my lord. I think this aspect has not been dealt with, my lord. That has been looked into by the way of, my lord, APSC. That is the contention we have.
What aspect who has not dealt with?
My lord, I was hoping that the OM, if suppose that would be passed afterward, my lord, and that point of might be it has been escaped.
So according to you, read petition should be dismissed.
That is my lord, outweigh.
Regularization is in terms of the OM. It clearly states the order of regularization states it's in terms of the
Whose regularization?
the other two persons. He's saying that they were
Where is it?
page 25, my lord. Page 25. In pursuance of the Personal Bill Department's office dated so and so, office memorandum dated 16th of March 2015. So my learned friend's submission may not be correct, my lord. But they were.
My lord, our contention is that, my lord, so far this issue is concerned, that is solely based on APSC appearance, my lord. That is because, my lord, other than this, other thing is not been looked into, because once.
Your contention cannot be more serious than your departmental officers' approach to the matter. They have been very, very casual. So your contention will be that only. All right. To conclude your argument. But you can argue on cost.
No, the cost, lordship, I can, my lord, say with all, my lord, respect that so far departmental part is concerned, my lord, kindly see, my lord, it is not a sole department that has taken decision. Personal department, judicial department, my lord, and this has been routed through that other department. And that stand of the judicial department, ultimately we have to rely upon. We cannot go, my lord, exceed to that limit, my lord. And this is the legal issue. That's why we have referred this matter to the judicial department necessary opinion. And that opinion, my lord, contain that because this is the issue, might be, my lord, their approach is wrong, my lord. But question is that, my lord, it is not a case that one person has taken the decision, my lord. It is a matter of rooted for the different department.
Mr. Gogoi, you are appearing. What is this? Have you seen the facts of this case?
I would only, my lord, submit on the point of this office memorandum, whether the petitioner is otherwise entitled or eligible, my lord, to get the benefit of the, my lord, this particular one that pays, my lord, 26. And if you can take away 2, I will, my lord, place that in part, my lord. To my
According to-
submission, my lord, he will not be entitled, my lord.
Why?
Well, the main basis of this, my lord, office memorandum is this, my lord. Those 3 appointees who are working for a long period of time in the 3 capacity, my lord. And in between their, my lord, service as 3 appointee, whenever such advertisements are issued by the APSC, my lord, they have participated in this particular selection, but they failed to be qualified. In that case, my lord, those left out persons, my lord, they were regularized person to this OM. It is very specifically mentioned in the OM. In the case of the present petitioner, he never, my lord, participated in the APSC selection. After being appointed as
No, but how many times advertisements were issued?
that, of course, my lord, the concerned department will have to say.
How many times advertisement was issued?
Lord, the advertisement part and filling of the post, my lord, the details that we have to collect. Afterward, how numbers of advertisement that has been issued.
You give us that. How many times advertisements were issued?
Detail we will provide.
My lord, that is, I have clearly stated, my lord, the advertisement went in.
My lord, we place details, my lord, we place.
There are 4 of the OM, my lord, clarified. Who will be the eligible person?
Your client never appeared.
No, no.
Why is that?
That is explained, I'll read it out.
Alright.
The
You
court-
want to say something?
Item number 22, Lord.
Yes.
It's there for tomorrow. Appearing possible.
22 day after tomorrow. You want some time to go through the record?
Yes.
Will 45 minutes be enough? Mr. Mohanty, what is your case?
My matter, this is pertaining to some disciplinary action taken. Some punishment was awarded on me. And I, because of that, minor penalty, but then my promotional benefits were held up. Ultimately, I was deprived of my due promotion in due time. I am retiring today itself. Therefore, it was brought to, prayer was made accordingly, it was listed. It will take, my lord, the short compass. The question is whether the CVC, Central Vigilance Commission's advice would have the influential value on the authority to take a call, and accordingly, although the report said.
You want to do it today itself?
On the subject to your
No,
lordship.
no, if time is there, the courts
Yes.
will rise early.
Yes, I think by that time it will be.
But what has that got to do with his retirement today? You get an order and straight away go and show it to them. Get a promotion today evening itself.
But it will.
Something like that. If it is something like that, we can try.
Well, yes, well, nothing like that, but then it would rather give me the benefit of my retirement benefits pursuant to your lordship's order if I can win the oath and get this.
And that
is
holds
only.
good whether it's today or tomorrow, or day after.
Yes,
Same
that is
thing.
one. A person will be retiring with a stigma.
You are there in this case. See, he is retiring today. Mr. Mohanty doesn't want to say this, but he is trying if he can get a hearing done, get an order, take a copy, give it to the authorities today itself and get a promotion by evening. Are you prepared for that? Huh?
The next thing, a
Why not?
person feel that his retirement benefits now has to be decalculated.
Actually, you don't want promotion.
Promotion already given, but too late.
Censure has also gone, my lord. It has lost its force.
All right, if you want to do it, then second up.
Oh, my lord can have it on a day.
You both agree, you want to do it today,
We will keep it.
or give it, take a day.
Our matter, my lord.
All right.
Our matter on Thursday, my lord.
Why Thursday? Why not today?
Not today, my lord. Lordship, I thought-
Continue.
Continue.
You make an attempt. If you can't, then we'll postpone it.
Well, in that case, my friend says he wants to drag the matter again.
We'll give a date, my lord.
No, well, it maybe
We'll take a.
today is a your choice. If you want to do it today, I'll hear it in the second half. So I think, Malad, it will not take much time. No, up to you. If you want to take. So, Mr. Bora, have you gone through the records?
Yes.
We can conclude it today,
Yes.
or you need time to consult the record. Make up your mind.
No, it is there. I've marked it. The Lordship may kindly peruse to the record.
No, you first tell us what you want to talk in the record.
Basically, first is the cabinet memorandum as to the regularization of the two candidates and not the petitioner.
There is a cabinet memorandum.
Yes. That cabinet memorandum, if your Lordship peruses through it, it's a secret, I cannot activate. It's a secret.
Okay. Give me. Here it goes.
RTR exception given, I will section later. Actually, what? National security. Because I'm very confident in security. I can't divulge it, right?
The regularization was pursuant to this cabinet approval. The cabinet memorandum approving the regularization.
Mr. Mohanto, you may have to do a lot of different work. If your submission is to be accepted, I'll have to dismiss the writ petition.
I'm
There
not
are-
aware about the content.
You better have a look at this. You have to show him the cabinet this. Because you have a look at this. Though what is written here may not be correct, but then the case projected by you, you have to go for a rethink. You see, there is a problem here. They appeared before the APSC, but after that, several times they were terminated. Then how can you take advantage of that?
And also one.
You make them party, we have to set aside their appointments as well. What else?
One more submission.
What I've been told by my learned friend, that the regularization was because of the cabinet approval or the cabinet approval of the regularization. But if your lordship refers to the regularization order, it does not speak about the cabinet.
Maybe,
approval.
but in the record
says-
it's there.
It says it is as per the office memorandum.
And then regularization by way of cabinet memorandum is not permissible under the law. There are judgments.
And also.
But anyway,
Also,
And my
what,
lords,
the problem is subsequently the posts were advertised several times. That is what you also agree.
Yes.
They don't know and you agree. Then if you agree, why didn't you not appear? You have to explain that.
My lords, that has been clearly stated in.
All right, you want the matter to be concluded today or you want?
My lords, any other time as per your lordship's
You
convenience.
better go through the record.
I'll.
There are lots of
Next day, my lords, I may be allowed to place some judgments. my lords.
lot of corners in the
My
matter. You have to argue on what is the relief that can be granted. The cabinet memorandum is faulty. That's what we find. How can you rely on an appearance before the APSC on a date after which their services were terminated? Not once,
many times.
twice.
They have been continuing.
And
on
then
the-
you yourself you are a petitioner in that writ petition filed in 1999. Have you mentioned that fact?
I'm not aware, my lords. I'll go
Then
through.
you have to withdraw your writ petition.
I'll go through the, my lords, whatever.
You yourself came to the High Court, all three of you, in 1999, filed a writ petition where there was an interim order. And in 2006, that matter was disposed of by granting leave to them to either terminate or continue. You're not aware of all these things.
I'm not aware. my lords. I'm not been instructed.
That's what
I'll-
I'm saying.
I'll take it.
You better go through this.
In fact, it was not drafted by me also initially.
No,
my lords.
there is nothing personal about these things. But you are the petitioner for us now.
Yes, absolutely.
Unless you explain, otherwise difficult.
There's one fact, my lord, which is admitted, that 28 years she was made to work by the department. And even the department was in her favor and time and again. my lord,
That's
they-
all right. That's a headline.
Yes,
We can't give a judgment on headlines.
exactly.
We have to go into what are the nitty-gritties of the matter.
I'll try and satisfy. you.
We'll have to see how it percolated, where is the discrimination, where is the only thing we have to see is 14 and 16. Show us where is the violation of 14 and 16. After reading this, whatever impression the court had, positive impression about your client's case, that is gone.
I'll have a look.
What is so secretive about this? Let him have a look.
Covered under section 8 of
Seal
ICAI.
cover.
No, it's
No
written,
seal cover business.
no, it's written secret, that's why.
No
Unless and until it pertains to the
we
sovereign.
know why it is secret, because it is prima facie. It appears to be a little doubtful on a legal touch to it.
Also, I've flag marked this, there is another flag 2, wherein the Department of Mines forwarded it to the personal department. And that contained.
Yes, all through there was unanimity that all three of them should be regularized.
No, because those, the petitioner did not appear in any APSC interview.
They also did not appear. Only once they appeared was in
only
'93.
once. They only appeared.
But after that, their services were terminated.
Yes,
There is no continuity.
no continuity.
Then how can that be used as the basis?
Also, one more submission, Your Lordship. As per the 16th March 2015, they have been appointed. Now, there is a line that however, those cases where the incumbent concerned have not appeared in the APSC test or interview, and those whose cases are sub judice are outside the purview of this OM. Now, those income that. those
That's
should
right.
be-
That's what he wanted to
So
argue.
they should have, in my own personal opinion, Your Lordship, they should have challenged this particular OM.
I remember what I'm submitting, my lord. I have got judgments. My lord, if your lordship peruses paragraph 2, it defines the class of people who are eligible. It says the class of people who have crossed their age to appear before the APSC or sit for interview. Now, therefore, my lord,
Mr. Mahanto, I recommend you go through this.
I'll do that.
You may know facts about your clients which you didn't know.
My lord,
It appears all throughout the authorities were in favor of regularization of all three. Suddenly towards the end, there was a U-turn. That U-turn is on the basis of other two appearing before the APSC. But that is obviously erroneous basis. Because after that, their services were terminated. How can you rely on that appearance to regularize them? Because in between, they were out of service. You can't give an answer to that. They were not in service in between. So there was a break in service. How will you regularize? Where is the order of regularization? How have you dealt with this period? Is there any order which gives them continuity in between?
That I'm not aware of.
Then you have to be aware.
And I have to see.
See, these are the questions the court will ask. After they were appointed in your own memorandum, it is written that they were terminated. Then again, they were reappointed. What was the reappointment order?
That the department concerned will.
Oh, you sort it out amongst you, who will do what?
Yes.
Yeah, but where are the continuity order? If there is no order of continuity, then how will you regularize on the basis of appearance before the service was terminated? That is totally erroneous. Then we'll come to the next limb. But in any case, then the court will have to set aside the regularization of other two employees also.
All the employees.
There is no other option.
so far as
There is
appearing.
no negative equity. Either you have to give the same treatment or it has to be set aside.
And they also have to be made a party to the lordship.
Yes. But what is so big about it? If the earlier appearance is not there, then we'll treat it that you have regularized them under the OM of 2015 and therefore same principally apply to her. That's all. We can't write a Mahabharata on these small issues. So many things have gone wrong. That's why these are fat files. We are sorry to say this. Terrible legal advice. This is what creates big matter. Otherwise, it's a simple case. People who do not have clarity or understanding of law, they keep on giving advices, put up note, this, that. That is what creates voluminous cases. We have to hear for 2 days. Public are not aware of this. Keep on hearing matters, write big judgments. Why? Because all kinds of contradictory things are done by the department. And finally, it is for the court to streamline everything. We have to deal with everything. Ordinarily, 5 pages, the judgments can be written. We have to write 25 pages. So somebody has to pay a cost for that. Now that time has come. somebody must feel the pinch. This is all happening, whoever feels like whatever is doing. You look at your opinion of your legal department. Are these people qualified to be in the judicial department? This is their opinion. They go in one direction, suddenly they do a volte face because they appeared. They appeared when? In 93.
Right.
After that, they were terminated thrice. So taking that, you regularize them in 2015. This is legal opinion. This is the legal opinion of a state's judicial department.
I understand.
Mr. Gogoi, you better give hyper technicalities will not work always. Hyper technicalities, you see, the question is, people should not be harassed. If the persons that come through back door, through some illegal means, all right, you allow them in, you recommend their regularization, you allow them to serve for 22, 25 years, and suddenly you say that your services, we don't want you.
Well, one more issue cropped up, when another court, why this issue was taken up. And petitioner was supposed to address on that point. This is regarding regularization of the service of the petitioner pursuant to the Umadevi Para 53. He is holding a sanction case. He has completed more than 10 years. Only thing whether 3-year appointee can be covered by this para 53. Because in 2013 itself, the financial return will.
Umadevi categorizes two kinds of appointments. One is illegal and one is irregular. Illegal is when there is no vacant post. There is no procedure at all. And irregular is when, say, there is lapse in advertisement or some shortcomings in the selection. So Umadevi says when there are irregularities and people have continued, he submitted that there were his client did not continue on court order, but that is a wrong submission. In 1999, his client has come before the court and there is an interim order. That order was in force till 2006. So there's no point asking him to address because he doesn't know that. He will not be able to answer the 5 questions I will put to him. But at the same time, look at the way the department is approached. The administrative department wanted to regularize them. The personnel department wanted to regularize them. The posts were vacant. They were serving regularly. Then suddenly an opinion comes that they did not, the 2 persons appeared in interview, other one didn't. So it cannot be. But then where are the facts? They appeared before the interview in 93. That list is over. The APSC regulations make it clear that it's for 1 year. How can you use that list after 12 years to regularize service of these persons when in between they have been terminated thrice? Is this what is expected from a government department? That's what I'm asking. And that too, when the files travel through the legal department, judicial department, they are supposed to be persons trained in legal issues. That's the question I'm asking you. And secondly, Umadevi never has stopped. You see, if you don't want somebody to terminate the service, you use the service of a person for your whole life. Obviously it's a sanctioned post. You admit it. Then you need the service. The person works in that. And then finally you don't want to pay the pension. Is it constitutionally the correct approach? That's what we're asking you. Somebody may have some idea, some discretion, indiscretion, that's another thing. But as constitutional courts, we will have to look at things from that perspective. And perhaps even the state should. The state doesn't want to, that's another matter. But the state also should do it. What is the answer to be given here? What is the answer? You have to maintain some parity. You have to maintain some transparency in your approach. They are your employees. You decide what you want to do. We'll have it on 9th of March. 9th. Please take it on 9th of March as fixed part. Yes.
Can I get a photocopy of
whatever you do, you do. That's not the
I'm deeply obliged.
Huh?
Deeply obliged.
But your projection will not take you anywhere.
In fact, I was about to address your lordship on MLKC and Umadevi. Perhaps what fell from your lordship now, I may not take up that point. Because
MLKC, Umadevi are on their own, then these judgments have been
otherwise, I was
diluted.
covered by MLKC.
No, that's all right. Regularization cannot be a mode of recruitment.
Right.
But the question is, is it not too late in the day to go into all this aspects? We have to open so many things.
Exactly.
We have to open so many things. Yes, next matter, please. There was a part matter, yes. Yes, any consensus?
We had a discussion. The only part that remains is for the period from 2010, when I was removed from service, to 2023. May I just place what was my proposal and what they tried to say?
But we'll fix it again on 9th, and that is the day we'll close it.
Just for lordships, I'm just giving my proposal. They have also given a proposal where I would not be entitled to anything from 2010, that is when I was removed, till today. I will not be entitled to anything, is their proposal. My proposal remains that, my lord. And my proposal is that the order of the removal has to be set aside. Appellate order and the revisional order also goes. I am allowed and deemed to have proceeded on retirement from the date of the orders of this honorable court. I be treated to be in service notionally from 14/9/2010 without actual payment of any area salary for the period from 14/9/10 to the date of order of this honorable court. However, my lord, the pension that they had granted me from 2010, when I filed the requisition from 2010 to the date of this honorable court, that pension I would have drawn during the pendency of the litigation. It is another matter whether they did not.
So what are you asking ultimately?
That part, my lord, the pension at the rate which they had given me, from today, the pension as if I would have retired from today.
Without any recovery of whatever they have given you so far. Obviously,
They have
that's
not
what.
given me anything so far, my lord. I have not taken anything from them from so far.
No, Mr. Majumdar, I've not been able to understand one thing.
My
Can you
lord.
be a little more articulate on
My
that?
lord.
The deliberations in the morning will not repeat it. Let us assume that the court is inclined to pass a judgment where the inquiry and the penalty will be
Set aside.
but will not direct a reinstatement. Therefore, the question is, what is the equity? In equity, what is the relief that can be granted? The court has to take an equitable approach, has to balance it. Your side, their side, it has to balance. So one way is to, instead of, if you are given as compulsory retirement with effect from that date in 2010, then you say that the amount comes to about 6,000 rupees.
They say it is 13,000. Let us assume 13,000.
All right.
Let us assume
13,000.
13,000.
But that 13,000 also they have not paid to you till today.
Not paid.
We are ready to pay, but he is not accepting.
All right.
That's a matter of fact.
And this is one option, and they continue to pay you at that whatever 13,000, 12,000, whatever it
Yes.
comes to, till the time you survive.
So my lord, that would not have any
No, no,
effect of setting
let's-
aside of the order.
Let's, so that would mean that although
Nothing is
the
changed.
same thing remains.
Nothing, sir, nothing.
The other thing would be that to treat you as a person who has gone on retirement
Yes.
on completion of 20 years.
My lord.
That will be with effect from,
I had joined in 2000. I had joined in.
oh, you are now looking
No, no,
for your record.
and just take it.
Thought you will be having this in your fingertips.
97, I joined in 97. So
97.
2007 and 2017, I completed 20 years.
Hmm.
So if they take it from 2007 also, that on completion of 20 years, I get my full pension on revised scale, which will now come to, per their calculation, 19,000 something.
So from, with effect from 2007, which date?
Uh,
Preparation level has to be a little better, Mr. Majumdar.
Date of appointment, my lord, sometime in 2017, my lord.
Tell me the date when we should fix it then. See, these are things the judges will have to figure out, and it will take a lot of time.
That date, my lord, I'm saying, just a phone call and I'll
Submit it when we have it next in the
My
month.
lord, that date from that, from 2017, if I'm taken to be.
17 or 7?
17.
17.
17,
Uh,
20 years of service complete. So from that day, my lord, they would calculate my pensionary benefits as if I retired on that day. The difference now remains from 2010, when I was compulsorily retired, to 2017. They had afforded me a pension which did not come to me. My proposal was they give me that amount of money
For
for that
those,
interregnum
for
period.
those interregnum.
Interregnum period. Their proposal is I get nothing, not even the pension, not even any salary for that interregnum period. That is what lordship will decide. I was depending upon the Deepa Kundu Survase case, which says that if it is set aside, I will be perhaps entitled to the entire salary. That giving up, my lord, I'm saying only saying what they had proposed as pension and which was not given to me, let that be given to me. I keep saying. Motion is
Your Honor, इसमें जो petitioner का request था, and in one condition he is saying that he be granted the full pension benefit from 2010 whenever he was
No, 2017.
no, first he was requesting that he from the removal of the compulsory retirement.
That he doesn't want.
अगर उसमें हम कंपल्सरी रिटायरमेंट करने के बाद फिर दोबारा 2017 में फिर दोबारा रिटायरमेंट इज नॉट टेक्निकली पॉसिबल, तो हम ये दे रहे थे कि आइदर यू टेक दैट remove compulsory retirement from 2010 or whatever compulsory retirement or VR we have from as he demands. ये था condition. Because दोबारा retirement is not technically possible. And at the 2010, whenever the order was passed, the money was to be granted to him and he's not receiving. We are ready to pay a full pension benefit even though he was not entitled due to non-completion of 20 years. वो तो हम देने के लिए तैयार था, नहीं हो पा
Full
रहा।
pension benefit from which date?
From that day of his removal from compulsory retirement in 2010 in May.
Alright, from that day, you are willing to pay him full.
We have given order that he is given, but he is not accepting that money.
That's
That's
a
all.
minute, just a minute. I'm trying to understand. What is the date on which you were sent on?
It is in 14th September 2010.
49,
First, actually, it was given removal, but it was set aside and the punishment was reduced to compulsory retirement with full pension benefit with effect from that date. That is 14th September 2010. We
Alright.
are ready to give and the department has
You are ready to give what?
full pension benefit.
Full pension benefit
Yes. Honor.
with effect from 14/9/2010.
Yes or no?
What is the problem?
That is what. If I'm given full pension benefit from 2010, that same thing continues. I am not considered retired in 2017. So that 17, the pay revision and everything had come where I would get an
A pay
enhanced
revision-
pension. What he's trying to say is that the compulsory retirement order stays as it is.
No,
So I
he's
don't
not
get any
saying.
benefit at all.
Why don't you let him say? He's saying. Let him say.
After he is given compulsory retirement in 2010, as per the pay commission, whenever it comes, his pay will be refixed. And at the time when he was given compulsory retirement in 2000, at the time when we have given him compulsory retirement, his pay was fixed at only 5,500
Listen,
something.
may I know your name, please? You are Mr.
Dineswar Tongbram, sir.
Huh?
Dineswar Tongbram,
Dineshwar Tomram. You are the commandant?
group commandant, heading group headquarter here in Guwahati,
Alright.
sir.
Mr. Tongram, please listen to the query of the court. huh? And
Yes,
then
sir.
your presence is required to assist the court.
Yes,
You
sir.
are not coming here as a contemner or something.
Yes, sir.
So you relax.
Yes, sir.
Just hear the question. We are trying to solve
Yes, sir.
a little cantankerous issue.
Yeah.
So that it gives something to both the sides.
Sure, sir.
Otherwise, we can hear parties and pass orders. We don't
Sure.
need to ask anyone.
Sorry, sir.
But the approach is because we are concerned about you also, they also,
Sure, sir.
right? Now, what I am asking you is, the petitioner was sent on compulsory retirement on 14/9/2010,
10, sir.
right?
Sir.
Now, he has challenged the inquiry report
Sir.
and the consequential penalty. If the court finds that there is some fault in the inquiry proceeding, then the normal recourse is to set it aside,
Sir.
direct his reinstatement back
Right.
with back wages and giving you the liberty to proceed afresh if you want.
Right.
But the court is not inclined to do it for two reasons. One is that there has been a lapse of about 13 years. He is a driver.
Yeah.
So the vehicles of your organization have to be in safe hands.
Sure.
We are conscious, we don't want to risk that. Secondly, there were warnings given to him earlier also, which goes to show that he might be, coming inebriated in the duty. But the issue is on that particular day, there is no medical evidence convincing enough to show that he was drunk. The evidence only shows he might be smelling of something, which could be alcohol, which could be betel nut. But the fact that he was in an inebriated condition, that your own witnesses have not supported it. So therefore, we don't want to penalize him by not reinstating him back. And at the same time, we want to protect the interest of the department.
Sure.
So what is the via media possible? That's what we are exploring. Now, 14/9/2010, he was sent on compulsory retirement. That was within 3 years, within 13 years, 12 years.
12 years, 11 months.
12
service.
years. Now, 12 years service, one will not get regular pension. One will not get.
But we were given our own compulsory retirement.
Compulsory.
Actually, he is not entitled for full pension benefits for 12 years of service, but he was given compulsory retirement with full pension benefits.
All right.
He is
So-
entitled for pension benefit for his whole life.
All right. So if you would have actually retired from service on 14/9/2010, then also he would have got the same benefit
Yes, sir.
as a
Yes,
pensioner.
sir. Yes,
That is your stance,
sir.
correct?
Sir.
But at that time, the scale were lower, so the amount was lower.
Lower.
Now with the revision, the amount has gone up.
Sir.
That is it,
Yes, sir.
right? So your department does not have any objection if he is retired from service with effect from 14/9/2010.
Yes,
Correct.
Sir.
But that is what you have already given.
Yeah, sir.
So
And
the question
increment-
is, he is asking that if you set aside the order inquiry, then I must get something. This is what I already got. Even if I didn't come to the court, I have
And
got it.
the increment of the pay is done regularly, sir. And at the time, he would be getting only 5,000 something, 325 plus DA. But at today's date, he would be getting 13,550 plus DA as the pay revisions. Pay revisions also happens for the retired persons also.
Right.
There is no change. So he will be entitled for all pay revisions. And he will be getting at present, if he had is assumed to be retired on 2010, he will be getting at present 13,550 plus DA.
That will be his present pension.
Pension.
If I had taken.
One minute, Mr. Manvi. Yes.
And even if he is.
What
given-
was his salary in 2010?
At the time, his salary was with the basic pay and grade pay, as per the sixth pay commission, it was 10,650 rupees plus DA of that time.
Okay, and his pension was at that time what?
It was fixed at 5,325 rupees plus DA.
All right.
And after pay commission, pay revisions, it has been increased up to 13,550 rupees at today's date.
At today's rate.
That would be the position if I retired in 2010. If I retired in 2023, if the retirement effect is given from 2023, my pension becomes 19,000 something, not 13,000 something. I get 19,000 something because the pay revision will only be effective if I'm in service on that particular day, the pay revision comes into effect.
So you are saying that
Retirement from 2023.
2023 full retirement.
Full retirement and from
No,
2000
retirement is fine. The compulsory retirement will go on, but in lieu of reinstatement, the court can direct that he will be given pay scale
So that
enjoyed by
13,000
employee retiring on the date of the judgment.
2023 and the interregnum which they were ready to pay me already, that 13,000. If I had not refused it as they say, or if I, as I said that they did not offer it to me. During pendency of the case, I would have got that money in any case during the pendency of the case. What I was praying is that money be given. Because I would have drawn it during the pendency of the case.
They are saying they offered, you did not take.
Malab, that will always remain a question of fact, Malab, whether the papers were sent to me and whether I did not sign it or send it back to me. That will remain a question of fact. since we are bringing a quietus to the matter, I was not going into that aspect. Because I could have shown that they had offered me 5,000. Today they offer me 13,000. 5,000 is something. Whether
So
I take it
therefore,
or
what
not-
is the way out? The court
Therefore,
is
my
not
lord-
inclined to direct reinstatement.
My lord, lordship will only have 5 and para B of my, this relief sought for my lord, 0.5 para B. The sub para of 5, the sub para.
Yes.
Therefore, lordship finds.
Yes, yes.
Therefore, from 14/9/10 to the date of order of this honorable court, he would be paid at the rate of rupees 13,000 and odd, as was his pension then. And from the date of order of this honorable court, as if he retired now. That was my proposal. What I would have drawn if I had taken it during the pendency, that is what they give me. And from-
So therefore, retirement term cannot be used twice.
At that point of time.
All we can say is that his pay can be refixed with effect from the date of the order by by bringing it at par with those employees
Who are retiring.
who are retiring now. Rest of the things remain same. This will be in lieu of an order of reinstatement.
Yes, my lord, but that interregnum period, what I would have drawn.
You
that
will
I'm
get
not
it,
being able-
whatever is there, you will get.
If they give it to me.
So, Mr. Tongbram, have you understood what we are saying?
Yes, sir.
Your compulsory retirement remains same. You will be treated to have retired with effect from 14/9/2010. And we'll say that in lieu of an order of reinstatement, we'll say that now his pension be revised and refixed with effect from the date of the judgment by giving it the current fixation as an employee retiring on that date would get. That's all. Otherwise, we have to ask to reinstate it.
Double retirement का मतलब आ रहा है
No, retirement double नहीं है.
The
Pay
first
fixation.
compulsory retirement दे दिया सर.
That will remain.
Let the.
और pay
Pay
fixation.
fixation will be only that. Only the pay fixation will be that. His retirement will remain the order you are, see, you have to understand, otherwise for us, the option is to direct him to be reinstated. You may file an appeal, but if you don't succeed, you have to reinstate with back wages.
Technicality.
That problem is also there. We have to balance it.
वैसे technically क्या आ जाता है वो थोड़ा देखना ही पड़ेगा, but
देखिए,
it's
Acha, you pay him the amount of pensionary dues. You
वो
pay
तो
him-
we are ready to be, but today till today he is not signing the paper. That's the only issue.
I have them some.
Then let him first get it.
Madam.
We'll postpone it for 4 weeks. You get it first. You take your amount that is due.
That was due till
Yes.
now.
And then that is tentatively what I intend to pass. Only thing is, he will, in lieu of an order of reinstatement, what the court can think is a fixation of his pension by giving it current effect.
In that case, the order dated 2010 has to be set aside. There will be the reinstatement or in lieu of will come. Therefore, what he was saying is compulsory retirement from 10 remains. Well, that part would not be there. My retirement would be from now.
You cannot have two retirement.
I do not need my. I do
So
not
only
need that
your
retirement.
pension will be refixed. That's all.
I d-
Your retirement will be on 14/9/2010.
Then I will not be entitled to the revision of pay. My
We will pass an order to the.
Yes, yes. If lordship, there's. That technically they were pointing out is what may fall upon me is what I was afraid. If
No,
lordship
no,
passes that order.
he says there can be two retirement.
We
Once
can
he-
give him compulsory retirement on that 14th.
compulsory retirement is also retirement.
And everything, only pay fixation can be done. That's.
Pay fixation can be done. If there is a court order, then nobody can have any option, objection to that.
So now I will ask the petitioner to fill up the forms at the rate of 13,000.
Whatever is.
Whatever
the-
is the- applicable at the time.
They will pay the money. We come back to the court, lordship disposes of the matter.
Heard Mr. R. Majumdar, learned counsel appearing for the writ petitioner, also heard Ms. A. Gayan, learned CGC, appearing for the respondents. On the request of this court, Mr. Dineshwar Tongbram, the group commandant of CISF, headquarter, Guwahati, is personally present to assist this court in resolving the issue arising in the matter, full stop. It may be noted herein that the writ petitioner was serving as a driver under the CISF authorities. And when he was posted in the IOC campus at Duliajan.
Oil.
Oil Duliajan. A departmental proceeding was initiated against him, pursuant whereto the penalty of removal from service was imposed upon the petitioners by order dated
14/9/2010.
14/9/2010. Full stop. The petitioner preferred an appeal before the statutory authority. Full stop. Taking note of the grounds taken in the appeal, the disciplinary authority, the appellate authority had modified the order of penalties.
Dismissed.
Dismissed. Huh?
Reviewing authority, yes, sir.
Dismissed the appeal.
After revision.
After revision of.
Dismiss the appeal. However, on a revision being preferred by the petitioner, the order of removal from service was modified and the petitioner was sent on compulsory retirement with effect from 14/9/2010.
Full pension benefit.
Full stop. Aggrieved thereby, the present writ petition has been filed. Full stop. The inquiry report dated
14/8/2010.
14/8/2010 and the orders and the subsequent orders imposing penalty upon the writ petitioner have been assailed on numerous grounds. Full stop. This court has gone through the pleadings as well as the materials available on record and prima facie finds substance in the argument advanced by the petitioner's counsel to the effect that the inquiry proceeding is vitiated due to violation of procedural safeguards. Full stop. Be that as it may, since the petitioner has been out of service since the year 2010, and considering the long lapse of service, this court was conscious of the fact that issuing an order that in the event the inquiry proceeding is held to be illegal, an order of reinstatement of the petitioner back to service with back wages may not be in the best interest of the CISF authorities. Full stop. It was in such perspective that the court had requested both the parties to address arguments as to what relief could be granted to the petitioner at this stage if the writ petitioner succeeds in showing that the inquiry report was vitiated. Full stop. After hearing the submissions made by both the sides, this court finds that the petitioner has not accepted a single penny due to him on account of the order of compulsory retirement. Full stop. The respondent's counsel is submitted that the petitioner has refused to sign the papers, as a result of which no amount could be disbursed till today. Full stop. On a query made to Mr. Majumdar, he has submitted that his client would be willing to sign the papers without prejudice to his rights and contentions in the writ petition. Full stop. Mr. Tongbram has also submitted, in all fairness, that if the petitioner submits the necessary papers, admissible pension due to compulsory retirement will be paid to him with effect from 14/9/2010 till the current month. Full stop. Situated thus, further hearing of this writ petition stands adjourned till 28th or 30th of March 2023, so as to enable the parties to complete the necessary formalities for disbursement of pensionary dues, admissible pensionary dues payable to the petitioner till date. Full stop. It is made clear that acceptance of such amount by the petitioner shall be without prejudice to the rights and to his rights and contentions in the writ petition. List the matter accordingly. You want a copy of this order?
Yes, Malad.
Copy of this order be furnished to this guy.
Malad, compulsory retirement, punishment is compulsory retirement from service with full pension benefit may be stated, Malad. That
Full pension
order-
benefit.
Order of
He
review.
was imposed the punishment of compulsory retirement from service with full pensionary.
Full pension benefit.
Mr. Majumdar, your client has got something which was not easy. 12 years full pensionary benefit.
That full pensionary benefits at that point of time.
That after 20 years, today what you will get, somebody will say it's nothing. You know what a peon gets in High Court today, many SES officers did not get it 10, 15 years back. So that is not an argument. Argument is they have also been in a way fair. Because 12 years you don't get full pension. We will balance everything. That's all I want to say.
That
We
is
will
why
balance
I just-
everything. There will
I'm
be
just looking
no,
forward what my client. will do.
both sides. We are also conscious that they have to maintain a force. They have to ensure discipline.
Lordship may remember that it was
They are the ones who are dealing with things in the ground level.
I had made that first submission
Yes,
that I do not want to reinstate.
that's right.
But he goes home hungry is my, the entire problem was.
That's
He
it. Let
goes
us
home
see.
without any-
Yes, please see that things are done at the earliest. And then we'll pass an order. If you want, you can come. Otherwise, your presence is not required. If you want, you can come on the next day. But that is the order we propose to pass. That everything remains same. No, in lieu of reinstatement, his pay will be refixed with effect from the date of the judgment. His pension, not pay. That's the order we propose to pass.
Yes, Honor.
All right.
Obligation.
Yes.
The government of India, the Home Department filed the VDP matter, but the parties who should file the VDP on this question of OBC certificate is the Deputy Commissioner and the WPTBC Department.
20 minutes. Is it
No, no,
enough?
WPT and Lordship government had yet to file affidavit, Lordship.
let them file the VDP.
Acha.
Lordship.
Acha, you are not asking for disposal.
No, no, but for that, other, without that, it will be.
You are appearing for whom?
Record number 6, Lordship, this
Respond number
Deputy
six.
Commissioner,
Deputy Commissioner.
You want to file affidavit?
Lordship.
And Mr. Gogoi, you are for?
Lordship, I am for central government. Lordship.
Yes, I know.
No, no, respond numbers.
The response numbers, Lordship, 1, 2, and 154, Lordship.
Yeah,
1 to 5, Lordship.
1 to 5.
It should take down hard Mr. R.P. Shamal, our senior counsel assisted by Ms. So-and-so, attorney for the writ petitioner, also heard Mr. K. Gogoi, Leonard CGC.
8
representing- Huh?
8 Alukdar, Lordship.
No, no, C. K. Gogoi for CGC for respond numbers 1 to 5. Ms. A. Talukdar, Leonard Council, Government Advocate Assam appearing for 6 and 7.
It's only 6.
Only 6.
7 is Lordship by WPT department.
Huh?
WPT department. Hard hold Lordship probably.
No, it is Deputy Commissioner of Bishwanath District.
Yes.
Seven,
Why are you
seven,
saying-
7 by her, 6 by Lordship WPT.
6 by level. So she's saying 6.
Lordship, we are not served with a copy, Lordship, and our name is also not reflected in the copy.
All right, then 7. None has appeared for respond number 6.
But you might not.
That means that she be granted 4 weeks time to file affidavit. Prayer allowed. 2 extra copies of the writ petition which punished Ms. Talukdar within a week from today. So as to enable her to obtain instruction and file affidavit. Let the matter be listed again in the first week of April
Lordship.
2023. By reflecting the name of learned counsel for both the sides in the call list. Right? Yes.